fact that, as you all know, we have an election coming up in less than 14 days, so it's going to be interesting to see. There's a lot of things that affect taxes, a lot of things that affect IRAs, different types of assets that you have, and so I know we're going to go over a lot of that information today. I think that's very, very critical, and pay attention to that because it is always changing, and it's important to understand how that works. Just as a comment, you know, again, we're very happy to be the sponsor this year. I think that, you know, at Hancock Whitney and the Private Wealth Group, we have a tremendous local presence. So we think that it's important to have a lot of folks on our team. I've got me here today. I'm actually a trust advisor, sometimes called a trust officer. I have a legal background, as I mentioned. I was an attorney for 14 years, practicing attorney. Jeff Danley's a private banker in the local area, primarily in the Destin part of town. And but we all kind of cover the panhandle. We have other folks on our team in the local area. We have a CFP that helps set up financial plans. We have folks that help with lending and that type of thing. And of course, we have investment management. So again, thank you all to the Estate Planning Council for allowing us to be the sponsor this year again. And I hope you all have a great event. And pay attention because, like I said, it gets technical, but there's some important things to pull away today. So thank you.
All right, I will introduce our first panel. They are going to talk about what happens after you pass away. We have Ms. Laura Dalton with Waldron Private Wealth. Dina Muldowney is a CPA with Carr, Riggs & Ingram. And Ms. Lisa Jo Spencer, attorney with Lisa Jo Spencer, PA.
So I'm going to get us started. Our topic is what happens after you pass away. It is obviously a very broad topic, and some of you may have questions if you've ever been through the probate process or trust administration process or just have had to deal with a loved one passing away. There's so many questions and so many different kinds of things that go into it. My practice focuses on probate, guardianship, and estate planning. So we touch on all the areas that we get into here today that you'll be talking about. But so basically, what happens? Well, we usually get a phone call, and probably my office as the attorney, we're the one that usually gets the phone call first, but it may be the CPA or the financial planner. It depends on where the relationship is. And a family member will call and say, oh my goodness, mom's passed away now. And my office's first response is, of course, we are so sorry, and we will, we're here to answer whatever questions. Take care of your family first. Don't worry about all of the financial stuff and all of that. You love on your people. You take care of each other, and you do your grieving. Now, that's not to say that there aren't things that you can do to kind of make sure that everything's going the way it needs to, because a lot of times people will wait, and then there would have been things maybe we could have helped with. So it's okay to give that phone call, but focus on each other first. I think we'd all agree with that. And so we get the phone call. What happens? Well, the first thing we want to know is, if it's not somebody we've worked with, is there a will? Is there a trust? What kind of stuff? And so the attorney's office is going to ask a few questions of you to kind of work through it. Now, what the rest of today is going to be about is trying to avoid that probate process. But a lot of times you just have to go through it. And even with the best estate plan, sometimes there's things that just cause you to have to go through the probate process. The legal office that you work with should guide you through that administrative piece. In Florida, probate is pretty technical, and it takes a long time. So if you're from another state that does things easily, some states, they literally just have to take the will to the courthouse and pay $100 or something, and it's blessed, and that's the end of it. They say, go do your thing, distribute property, and do all of that. If you're from one of those states, you are in for a very rude awakening if you have to do probate in Florida. And so that's why most of us in this room we push the, get your affairs in order and avoid the probate process. It's expensive and it's time consuming. And that's money that comes away from your loved ones because, guess what? The attorneys and the CPAs get paid first. But yeah, so you want to do that. So I'm going to let these ladies talk about ways that they can help you with avoiding probate, and there are things that we talk about. The one thing I think every single one of us that are in here will tell you is there is no cookie cutter for this. Estate planning is very, very tailored to what you own, who you want to leave your things to, who you want to take care of you, because remember, it's not just what happens after you pass away, even though that's our topic, it's what's happening, if you've had a stroke or something and somebody's got to help pay your bills. So we'll let these ladies talk about some beneficiary designations and things like that.
Sure. And again, I'm Dina Muldowney with Carr, Riggs & Ingram, and we also get the phone calls. And so, one of our first questions is, do you have an attorney? Do you know who the deceased financial planner is? And we'll have them come in to the office, because you kind of, even though during these times, sometimes a face-to-face can make somebody feel less anxious about what's going on, and they'll say, I'm identified in the will to take care of this stuff. And so usually my first thought is, oh my gosh, do you know what you've gotten yourself into? And usually they have no idea. So, when you kind of go through the process of everything, it can be overwhelming. So we kind of identify the steps that need to be done. Then we'll put a timeline on those steps. There'll be some homework, but that way they know they've got something to do, so they're doing something, so that makes somebody feel better. And then they know they have somebody that they can call, so that makes them feel better, and they don't feel quite so overwhelmed. Like Lisa Jo said, it's usually a year at least, sometimes, to get all this stuff wrapped up, which people don't realize. That's like signing on to a full-time job. And if you ever go through it, you know what I'm talking about. So when we bring someone in, is there a will? Is there a trust? What kind of documents do you have? Do you have contact with the estate attorney? Do you need an estate attorney, which in most you usually always do? So, their first task is to identify what assets are owned. And we have several ways that we can do that. Since I do tax returns, a lot of the assets are identified on the tax return. So that's a good way to see what bank accounts are there, what investment accounts are there, retirement accounts, property taxes that are being paid. So how those assets are titled determines what kind of processes will go in place after that. So that's pretty much the first thing. And then that also shows us how those assets are titled. So depending on how those assets are titled depends on if there will be a probate, if there's a trust, if things are held jointly, and then that will dictate the next steps to move forward in the process. And so we rely heavily on the attorney to tell us what the language in those documents mean, to do probate if probate is needed, and then the investment advisor can confirm how assets are titled. There's a process you have to go through. You need to get the assets out of the Social Security number of the decedent, because when someone passes away, the power of attorneys don't work anymore. So do they need to be officially appointed as the personal representative is something that has to be determined, and the estate attorney will take care of that. So there could possibly be a probate if there's the financial advisor can tell you how those assets are titled, which can confirm how, if we need federal identification numbers for, say, the estate, because the estate could be required to file an income tax return. So the day that that person dies is the final day that's reported on their personal tax return, the Form 1040, and the estate starts. So the estate's responsible for an income tax return as well. And if there's a trust, the trust is responsible for an income tax return as well. So the financial advisor has a lot of roles, and I'll let Laura talk about what some of their roles are.
Hi, I am Laura Dalton. I work with Waldron Private Wealth. So I'm just here to kind of talk about some of the headaches you can and tips and tricks that I have seen by going through this with my own family members and also clients as well. One of the big things is beneficiary designations. That is reviewing any of the designations you have on your 401k, your 403b, IRAs. You want to make sure that that money is flowing to the right people. Might have seen maybe an ex-spouse on an IRA, and you don't want to get into that messy thing at all. But with that, there was something that happened in 2019 called the Secure Act, where with an IRA and these retirement accounts, you were able to stretch them over a longer period of time. For example, if you were an 80-year-old and your spouse was no longer alive, and you had a 40-year-old child, you could leave that money to the child in this retirement account, but they could then stretch it over their lifetime, so 40 years. With the new rules, they have to take the money out within 10 years. That's a big change. And what a big change, and why I bring that up, is the tax planning that goes around it. When you're taking distributions out of an IRA, if it is not a Roth, they are ordinary income to the beneficiary. Now, people might think, like, oh, I'm dead, I'm in the ground, like, my beneficiary can pay the taxes, but if you actually like your kids and you want to do some tax planning for them, and you're not in the ski club, which I call the Spending Kids Inheritance Club, you can actually do some planning for them ahead of time, and you can do some Roth conversions and distribute some, or do a distribution out of those retirement accounts and put them into the Roth, and you would pay the tax. Another thing I want to bring up that seems kind of small are death certificates. If you're ever going through the process with a spouse or you're the executor, please order more death certificates than what you think. They never tell you that every company under the sun is going to be asking you for death certificates. Bank accounts, investment accounts, if you're filing a life insurance claim. Another thing, utility companies. If you think you hate your cable provider now, just wait. So please order more death certificates. In the state of Florida, the first one's $15, and then the subsequent ones are $4. So please order, there's two different kinds. There's a long form and a short form. The long form has the medical reason for death, and the short form does not. So please just order a mix of both, depending on, like count how many things you think you're going to file a claim for. Another thing I kind of want to talk about is your actual credit. So if you have somebody that passed away, that you're the executor as well, please go to your credit reporting agencies and file a do not issue credit on that deceased social, because no one can go and buy a new car or issue a new credit card into that social or go buy the new iPhone 12. So please go issue that thing. And also in the state of Florida, as we all know, they go after the elderly, and their fraud is very rampant down here. So please go put the fraud alert on there, because we've all received the email from the Ethiopian prince that wants to, your cousin was in Europe and you need to spend $10,000 to get them out. I told them to keep her. But please do that. It's just a helpful hint. And then something I wanted to touch on really quickly is Social Security. We could probably talk this entire day about Social Security, but please file the death with Social Security as soon as possible. The funeral director usually does it, but just a rule of thumb, please reach out, because if a distribution goes into your bank account and it's after the date of death, the deceased date of death, they're going to be looking for that money. Yeah. So you would have to pay it back. So please go and do that. And then if you are an actual beneficiary of the Social Security, please work with a trusted advisor on going through how to take that Social Security. There are so many nuances when it comes to Social Security, of the age, what year, like if there's a minor child involved, if there's a disability. So please work with anyone here on the State Council or any of your trusted advisors to go through Social Security. These are the things that I have seen that cause major headaches for families. So if you kind of keep these in mind before a death kind of prematurely happens, that you're prepared for these things.
If I could jump in, on your tables, and for those of you that are watching at home, I think RJ has a way for you to download this document. It's a little form that says important information on it. this is something that we created. We had stolen a form from the base that we liked, but we've found that it has sort of we've aged out of it because we realized that form didn't really account for people who handle banking online and do a lot of online transactions. So there's no magic to this form. You can recreate it yourself. What this form is for your loved ones, and this is one of the things we always ask for. Did they have any kind of a list or any kind of a thing that tells you where their bills, what your bills are, and where the assets are? Kind of like what Dina was talking about. CPA is the best person if we don't know where those things are. You would be surprised. Maybe you wouldn't be, but how many people come in and they have no idea where their loved one banked, who their financial advisor is, who their CPA is, what kind of bills they had, and all of those kind of things. So the first thing we also tell somebody is anything that is an individual bill, such as a credit card that's in an individual name of the decedent, don't pay it until we tell you to. Because if there's all kind of rules on that, and they may or may not ever get paid. The good news is you are never personally responsible for those accounts that you didn't take out yourself. So even if it's something that was your spouse's credit card, but it's in your spouse's name, your spouse passes away, it could have $25,000, $50,000. We've seen it. You can have it. But if there's no probate process, and so there's what we call no non-exempt assets to pay those creditors, those bills don't get paid. Well, you don't know what a relief that is. We've had several widows come in whose husbands had a gambling problem. We've had a couple of those where they had a gambling issue or something, and they hid it all these time, and then they've got these credit card bills, and they're like, well, what am I going to do? And we're like, good news is you don't have to pay it. The problem is what that may mean. We may be making a discussion on, well, they've got, there's a secret account too that's got $2,500 in it. Well, guess what? Forget that, because that $2,500 is going to go to that creditor. So, we go through all of those kind of things, and just that little bit of a simple, don't pay that bill until we tell you. Now, the rule of thumb obviously would be pay the mortgage on any real estate and keep the power and all the utilities going on real estate so that you don't run into issues. But cancel the cable bill unless somebody's going to be staying there and needs to have it on. But you can start canceling the cable bill, cancel the landline, cancel those kinds of expenses. Keep the yard guy on, and if there wasn't a yard guy, get a yard guy, because you want the house to continue to look like somebody lives there and it doesn't look run down. But those are the only bills that you really are going to, at the very beginning, keep going until your lawyer tells you what's going to happen with it. And so I know that seems crazy, and speaking about their credit, once you've passed away, you know what, we don't care if you have a good credit rating, because that's, oh, my mom would be so upset if she knew I wasn't going to pay this bill. Well, maybe, but the law says you don't have to, so don't do it. So, and sometimes it's a $50 bill or something, so the trouble of not paying it is almost worse than paying it. So, there's not a black and white, as with everything, but that's what all of us are here to help you with. The other thing, in speaking about beneficiary designations, it's not just those big accounts that you've got with your financial advisor and where your IRAs are and those sorts of things. That $500 credit union account that you've got so that you can have a good car loan, or that is your Christmas mad money, please put beneficiary designations on those. Because if we've avoided probate for everything except that account, it's going to cost more to try to get that money, and you've just left money on the table that could have gone to your family, could have been used to pay for your last expenses and those sorts of things. I will tell you, the funeral home is one of the first bills that you do have to pay. If there's insurance, they will work with you. They all have a different sort of a plan, but they can hold your death certificates hostage, and you can't do anything without a death certificate. So you've got to make those arrangements on how that payment is going to be made. So even though statutorily there's a method for them to get paid, the reality is you're going to pay them up front. in some way, or make some sort of arrangements with a life insurance policy that's coming in or something, because you'll need those death certificates. And talking about the death certificates, there is no rhyme or reason to who wants a with cause of death and without cause of death. So you have to order a bunch of both, and we can always order more. I mean, we routinely order them. A lot of times we have to order it for, it'll be the second spouse that's passed away. The first spouse, no probate was required, and so there's things that we have to do. So we'll have to order death certificates for the predeceased spouse and that sort of thing. But that's what we're all here to help you kind of walk through. Also, those beneficiary designation things and life insurance and all of those, every company has their own way and own forms that for the beneficiaries to get the money that's coming to them. And sometimes it's an easy process, sometimes it's not. If you've got a trusted person that you've worked with the whole time and you've got a relationship with the company, obviously that's much easier because those folks are going to walk you through it. We've got several folks here that are in private banking and that sort of thing. Those guys are going to make it very smooth for your family members if you've got that kind of relationship. That doesn't mean that if you're at the credit union or whatever, wherever your accounts are, that they're not going to work with you. It just sometimes can be a lot smoother if you do have a trusted advisor. We're in a small town, and so that's nice because we do, I think almost all of us have a personal relationship with a banker, no matter what bank that is. And so you can call around. All of us also, because we're in the estate planning council, but also just because we're out and about in the community, have relationships with most of the local banks. And so we can sometimes make those easier phone calls. We know there's some tricks to the questions that you ask, because if you're not a beneficiary, they're not going to talk to you. It's just that simple. But we can ask some questions to know there's formal administration probate, and then there's a summary administration that's much faster, less expensive, and it's much better to go through if you can qualify for it. We can usually get those answers from the financial institutions to know, because there's a cutoff on all that, to know, are they going to qualify for summary? And they know that answer whenever, they know when we're asking that question, they know what we're asking for and why we're asking it. They're not going to give us a dollar amount, but they'll say, no, you're going to have to file formal, or yeah, you know what, this doesn't have that much in it. You'll probably be able to do it. And then the next question we'll say is, well, summary administration's about $2,500. Is it going to be worth it? And they'll tell us yes or no on that too. So we can kind of get those phrases. They probably won't tell you that, but because we've got those relationships and they know we're not asking who's the beneficiary, blah, blah, we're not asking those kind of questions. We're just trying to get some answers around the bend so that we don't open a formal administration if we don't have to, and that sort of thing.
So, like Lisa Jo was talking about the funeral expenses and stuff. So, once we've counseled somebody and they've identified the assets that the decedent owns, then we have to help them, again, transition those assets out of the Social Security number into the new entity and the new federal ID number for whatever is next. So if we know that there's individual assets, those will probably be transferred into an estate account under the estate ID number. If there's a joint account, it will transition to the joint owner with their Social Security number. If it's in a trust, then it'll transfer to a trust account under the trust federal ID number. So it's the day after that person passes away, the personal representative is responsible for keeping up with the income and expenses of the new entity. And the income and expenses will be reported on a new tax return and a new different kind of form. So all that has to happen before anything can be distributed to the beneficiaries. And so, there's a lot that is involved before things can be distributed to the beneficiary. So once all that has been done and you've identified and paid all the final expenses, then you can do final tax returns and the assets can be distributed to the heirs. So there's a lot involved in between that and a lot of responsibilities in getting that done. And like Lisa Jo said, sometimes we see that people do the great estate plan. They do the will, the power of attorney, the health surrogate, a trust document, but they leave that 1 or 2 baby accounts out, and then they've done all this great estate work, but it didn't accomplish everything it could have accomplished.
Right.
So reviewing those assets before you pass away is a great thing to do to make sure that the transition will be smooth. Because probate can be expensive. And one of the hiccups we see is a lot of people have individual stocks, like Walt Disney, AT&T, there's just like Coca-Cola, certain companies that people have individual stocks. Well, it's hard sometimes for the personal representative to find out where those stock certificates are. So to get those assets transferred, you have to get a medallion stamp with the bank, and that in itself is like a big headache and a long process. So just keep that in mind, as well as like a helpful tool to help things transfer more smoothly. So you definitely want your docs in order. When you have a beneficiary or a transfer on death listed on an account, that overrides anything the will
Yes.
or trust says. So be cognizant of that. If you're trying to equalize your estate, you know, those beneficiaries on an account, that's where that money's going to go. It will avoid probate. That money can't be used for anything else except to go to the beneficiaries on that account. So make sure your beneficiaries are updated on your retirement accounts. And a personal financial statement is always a good thing to keep annually and update it. And you know, you may want to let someone know where that is or give it to them annually for their file. And Lisa Jo's talked to me a lot about like the passwords on accounts, you know.
And if you notice on this little form, that there's a place for that, and that's one of the things. People need to be able to get into those, into even your social media and all of that. They passed a statute recently, well, actually it's not recently anymore, it's been a while, but the digital assets pass. Now there's all kind of rules with that, and if we don't have that right language in paperwork, it can cause all kind of issues. But just if you've told somebody your login and your password, once you've passed away, you know, if you've got it on a piece of paper, they can at least get in and see what you've got, and that's where these kind of things come in handy. Like I say, there's no magic to what it needs to look like, but have it somewhere where everybody can get to it.
And also when those like investment accounts or property transfer to the heirs, they transfer at a stepped up basis. So you get the date of death value. So it's important to work with the financial consultant to make sure when it goes from the Social Security number into the federal ID number of the new entity, that that stepped up basis is picked up and reflected on those statements.
And just to reiterate, she mentioned it once, but we keep talking about these baby accounts that really could mess things up and cause more strife later. Just remember, transfer on death, TOD. That is what you need to ask your banker about to be able to put that on those accounts. And another thing to mention, it does stink to kind of go through and think about like, oh, what happens when I die? Like, what do I want? The more you think about it, the more you put in your will, the better it is for your family. I recently went through my father's death in the past 2 years, and I work in the industry, and I was overwhelmed with the type of questions they ask you when you go to the funeral director, and they're asking you, like, do you want 2 days? Do you want flowers? Do you want food? Do you, like, the more conversations you have with the family about what they want, you know, when they do die, just have the conversations, because it will save the family so much stress, because those decisions you're grieving.
Yeah.
I don't even know, like, what right side was up. It was, yes.
When my grandparents passed away, you know, they had the prepaid funeral, but they also actually had the clothes laid out with a big sign, bury me in this. Well, I was so happy they did that, because that was one less thing you had to think about. But, I mean, that's thinking things all the way through.
Yeah. Well, and along those lines, I mean, you just have to make sure that every single one of these little things are taken care of, and they seem, like they're saying, they seem overwhelming. But, you know, you can go, and I definitely recommend, as you're thinking about this, we don't have somebody from the funeral home here, but we've got some great planners for that around as well. my caution to you, and I think everybody here would tell you the same, is make sure you're comparing apples to apples when you do go do that prepaid funeral, because not all of them are the same. Some of them don't transfer to another state. Some of them, there's additional expenses if you die out of state and you have to come back. Some of them, that's included. So you just need to make sure. And now, while you're not, and this is where, the other thing, exactly what Dina's talking about, you get to plan your funeral. If you want it elaborate, you've paid for it. You've got it exactly the way you want it, down to the music and everything if you want. But if you want it to be simple, and then you say, then you've got that planned out. And you tell your kids or whomever, this is what I want, I've already got it done, don't do anything else. By not knowing, the family, just exactly what they're talking about, the family doesn't know, and you're feeling guilty, and you think you need to do, oh my gosh, what will they think if we don't do this and that and the other? You know what? I was just at a funeral last week, and it was beautiful, and I have no idea. I didn't pay much attention to what the casket really looked like. I didn't, as a visitor, I was just sad for the family. But you don't think about that when you're the one going through the grief of the person that you've lost. You oh my gosh, I need the biggest and best flowers and all that kind of stuff. If you plan it yourself, you get what you want, and you've taken that pressure off the family.
Question.
Yeah.
Can you talk about real estate, like your
Sure.
residence and
Yeah.
other properties? Yeah, real property with. Yeah.
Sure.
Panelists, when they ask a question, make sure you repeat the question and your answer for the online audience.
Okay, so the question was, can we discuss how real estate passes, and are there ways that we can even avoid probate, and what happens with real estate? So the short answer is, if you die with real estate in your individual name, there will have to be a probate wherever that real estate is. So this is where a lot of times you may not need a trust for tax purposes or for other purposes, but if you own several parcels of real estate in other states, it a lot of times makes sense for us to put you in a trust so that you've just got one administration that you have to go through, and it's a much more abbreviated, hopefully, administration than what the probate process, and having to do it in each of those states. However, just as Dina was talking about on bank accounts, if you own your real estate, and this is where so many people try to do this themselves. Oh, I'm just going to add, Susie to my deed. Don't do that. The whole room in here would echo. Don't do that. You've messed up your step-up in basis. You've caused all kinds of crazy problems that you don't need, and you may or may not have done it had the right language in it to where it still might have to go through probate. So anytime you're thinking of doing those things, Florida and about half of the states do have what I refer to as a transfer on death deed. It's got a technical name, but that makes it easier for everybody to understand, and any other estate planning attorney or financial planner in another state will recognize it too. But so there's ways we can even not have to, if everything's in Florida, we can do these deeds that don't have they're not considered a present gift for the IRS or Medicaid or any of those purposes. They don't affect a mortgage. So if you've still got a mortgage on your house, you can still do one of these deeds because it's not a present gift. You still retain the whole bundle. You can still sell it. You can still, I always say, you can burn it down if you want to. Your kids can't get mad at you. Or whoever you have as those beneficiaries that are on that deed. They can't get mad at you. And you can change your mind and say, oh, I'm mad at Susie, I'm going to give it to Tommy, whatever. But those deeds are there, but do not try to do it yourself. You need to do it with a lawyer, because if you don't get the words right, then you've messed that up too. So,
Yeah, like Lisa just said, don't just go add somebody's name on there for a reason. And when you put property in a trust, you can still, the revocable trust, you still keep your homestead exemption.
Yes.
So there's no harm, no foul. And if you do have property, sometimes it's good to talk about what you want done with that property when you pass. Like, if you've got a lot of kids, you don't want them fighting over things, and you're trying to equalize stuff. So sometimes maybe you just put in the will, please sell this and distribute the cash. Or if you have a beach house that you want to stay in the family a long time, consider maybe putting it in an LLC or something and funding a bank account to keep that going for 10 years. So analyze, the purpose of the properties that you have and what your intent is long-term for those. Yes?
You mentioned you keep the homestead exemption if you have a revocable trust. What if you, for whatever reason, after consulting with Joe or whoever, you want to have a not revocable trust? You still keep the homestead exemption?
No,
Can you repeat the question?
sure. The question is, do you continue to keep the homestead exemption if your homestead is placed into an irrevocable trust? So those would be the Veterans Legacy Trust, and sometimes there's other reasons for people to have irrevocable trusts. And I don't know the answer to that, and I'm embarrassed that I don't, because I've never had it come up. I would think because with an irrevocable trust, you as the grantor and you as the beneficiary have no longer any control over it. My gut would be you lose the homestead exemption. So law school exam right here for me? Sorry about that.
James? Thumbs up?
So, but
Thumbs
yeah, so if you want to maintain, and in our, homestead happened to be what I wrote about in the supplement. There's two kinds of homestead in Florida. So there's two things that people talk about, and that kind of confuses people as well. There is the homestead exemption, which is created by the Florida Constitution. That's the one that says creditors can't kick you out of your house if it's your homestead. If you file bankruptcy, you get to keep your house, those sorts of things. Same thing when you pass away. Creditors can't make a claim except for the mortgage company. But creditors can't make a claim against your homestead. That passes to your children free of creditors' claims. But you got to jump through do those. But then there is the homestead exemption that everybody thinks about for the taxes, that you get the $25,000 or whatever, all the different ones that they've got out there. That is a statutory tax exemption. If it would be much easier if they didn't call it the same thing, because it gets very confusing for family members. You can qualify for the homestead that protects you from creditors without having even ever filed for homestead on your homestead for the tax purpose. The other thing where this comes in, when we talked about death certificates can play a part in messing up whether you get to keep that homestead exemption with that has the claims that protects you from the claims against creditors. If you don't have the residence as the homestead on the death certificate, they've got all the different things. The residence has to be that homestead address. Even if you were in an assisted living, if you hung on to your house, the government says we know everybody wants to return home if they can. And so there's a legal fiction that gets created that you're going to return to your home even if we know that you're never going to. So it maintains its homestead status. There's things you have to do for that. But that's where, when you go through the death certificate, make sure the residence is that, or maybe you'd moved in with the kids for that last month or so. Yes, you died at your child's house, but the residence is still your residence. So and we can always get the death certificate amended, but there's another, takes some time and another expense.
I just want to mention something quickly with homestead. I know a lot of people here have beach houses that have been in the family for a long time, and maybe the property taxes haven't been reassessed in a very long time. And also with the boom in real estate down here and real estate prices, that when you actually decide, like, hey, I'm going to move from Illinois and come down to Florida and file my homestead exemption. When you decide to file your homestead exemption, if they haven't looked at your property in 20 years, they're going to be looking at that property, and all of a sudden, maybe you're paying $5,000 in property tax, you could be paying $20,000 in property tax. So please, when you are moving down here from another state to become a Florida resident, to talk to someone before you file for homestead exemption, and it's the right choice for you because of property taxes as well.
So I think we're going to turn it over to Amy so she can introduce the next panel. And we have business cards in the back, and we've all published articles in the supplement, so you can also get our information there.
Thank you.
Yeah, great job, ladies. really great job presenting a lot of information in a little short period of time, so thank you. So our next topic is very exciting, new laws in estate planning. Yes or no? Okay. Yeah, so our panel members are Mark Dutram with Bayview Private Wealth, Luke Smith with Blue Point Financial, and Jane Kerrigan with Hand Arundel Harrison Sale.
This is the topic you all signed up for. This is the most exciting one, I guarantee you. Yeah.
Sir. Starting it off. Okay. Hello, everyone. Luke Smith, Blue Point Financial. I'm taking, as we're going through the last 3 tax acts that we've seen in the past 2 years, and going to touch on the estate planning issues. Obviously, there's a lot more to these acts that we could be here, like we've said before, all day talking about each individual one. So, going to try to keep it to estate and trust related issues as much as we can, and then some pieces of it will obviously be related to individual situations. So, I'm going to talk about the TCJA, the Tax Cuts and Jobs Act, that was passed in December 2017. Most of these pieces of this act started in 2018, so you've probably already been affected by most of it. So, excuse me, my mouth dry. So the first thing in the estate and trust arena is the tax brackets. You know, you're pretty familiar with the individual tax brackets. There was a change to that as well, but the biggest change is in the estate and trust tax bracket. And the big part of that is, thank you, is the top tax bracket. So in an estate and trust, if they have income, they're needing to file taxes, then the income is a very big piece of planning opportunity to save dollars for the estate and the trust for the beneficiaries. As you can see, or my slide here, I think we'll get up there, but it's the top tax bracket in an estate or trust is $12,600. That's 37% tax at that point. Of course, as you know, it's a progressive tax bracket system, so any money over $12,600 is then going to be taxed at 37%. In relation to the individual tax bracket, the married filing joint bracket, highest bracket is $622,000. So there's a big, huge difference between the two. So there's, you know, the different types of trusts that we have out there. Perfect, thank you. So we've got, you know, if it's a simple trust, you know, most of the time those income dollars flow through to the beneficiaries, where we're going to get the tax benefit of paying at a lower rate. But if you got a complex trust, those dollars may stay in the trust, and that's where you're going to see a huge difference in taxation between the money flowing through to the beneficiaries and the money staying in the trust. And you know, there's not a whole lot. At $12,600, you can get there pretty quickly. And at the same time, some of these things, some of the income that comes through a trust, it could possibly be zero tax if it passes through to the beneficiary. No, that's the pointer.
Yeah, the bottom one.
Sorry.
It's okay.
One of these places.
Yeah.
Anyway.
The bottom button?
Yeah.
It's not working? Oh, hang on.
All right.
Let me, I know why.
Gotta engage it.
That's all right. So in that, where I mentioned that the tax or the income passing through to the beneficiary in a capital gain situation, the individual rate for married filing jointly could be 0%, so 0% tax up to $77,000 of income. So If something, the situation presented itself where the tax stayed in or the income stayed in the trust, you may be paying 20% on that, where if it passed through to the beneficiary that might not have a lot of other taxable income, they wouldn't pay any tax. So you can easily see the difference there in tax savings and planning needed with your attorney and financial advisors to know those tax implications so you can make the best decision, and with the goal of keeping as much funds as possible. Let's try that again. There we go. All right, so a couple other things that I wanted to also touch on is in the TCJA, the charitable donations. Typically, it's been a limitation of 50% of your AGI. That changed to 60% for cash donations. So if you have a little more giving personality, then this would be the time to do it. And Mark is going to talk about the CARES Act, which also changed it as well.
Right.
And it comes out to be, what, 100% of your
100%.
AGI. So if you are charitable inclined, now is the time, the tax savings is as big as it's going to be. And that, I believe that goes through the end of the year for the CARES Act. So couple other small things that in this that some other pieces that might hit or affect us on the trust and estate side. The financial advising fees, they're no longer deductible as a miscellaneous itemized deduction. That has caused some heartburn for sure when they come to see me and they ask me, why can't I deduct those fees? So I say, go talk to Mark about that. I'm sure he'll work something out.
Thank you, Luke.
Yes.
Thank you, Sal.
So there's another thing that was in the TCJA that can affect estate plans is on the divorce side. If you have a divorce, alimony and being expensed and taxable is no longer in effect after 12/31/18. There was also an increase in the ABLE account where you can contribute more than the annual contribution or annual gift of $15,000. And Mark was going to touch base a little bit on that for us to give us a little bit of understanding what the ABLE account is and how that works.
Would you like me to?
Sure, go right ahead.
So the ABLE account, again, is a great way for those with special needs to be able to qualify still for government benefits. So if they had SSI or if they had Medicaid or things like that, it's an account that's kind of an exempt asset up to a certain point that, again, you could put funds into and, still provide access to, capital for spending, everyday life, which people with disabilities have. So what this has done is has actually allowed you now to not only contribute the $15,000, which, by the way, you can have yourself do or family members, but now if that person is still working, and matter of fact, we have a client whose daughter's still working and, is able to now contribute up to $12,000 to the ABLE account and still, qualify for tax-free income. Another thing you could do is 529 plans. So 529 plans can now be rolled over into an ABLE account, and instead of just being able to use those funds for tax-free for education, now they can use them for a much broader scope of spending from the ABLE account. So very good there. And then they're also maybe eligible for a saver's credit, right, for making a contribution to their own ABLE account if they're working. So lots of good expansion that came from. Anybody have ABLE accounts in here? I mean, Florida has a great ABLE account, and if you need more help on that, either text in on the chat, right, or chat in and ask questions. We'll be glad to help, and anybody in the audience.
Thanks, Mark. So another big, huge piece of this, and this has changed everybody in the room's thoughts on a lot of how estate and trust planning is done, is the increase in the estate and gift lifetime exemption. So it's always been around $3 to $5 million per person. With the TCJA, it jumped up to 11.2 per person. So then 22 for a couple. So that is a big increase. I mean, you see a lot of estates, with some good planning, they could easily get to $5 million range here, over a lifetime. But with this exemption up to $11 million, it certainly helps the thought of, hey, am I going to have an estate tax? And it has changed how we, draft estates and those kind of things, or trust. And it kind of has made it a little bit easier for everybody, just having that big exemption, because just the amount of people over that obviously is not as large. So that has been one of the bigger changes for our industry since 2018.
If I could just make a comment on that too. I mean, those of you that have done trust, I remember, gosh, in the 2000s where it was $675, right, for the exemption. Those of you that did trust years ago may necessitate some amendments to those trusts where you were trying to plan for estate tax exemption or things like that, the old AB trust, the bypass trust credit shelters, you might now want to rethink how you've structured those documents. So see somebody like Jane, you had to go in and talk about those kind of things.
And yeah, I would say that's one of the biggest things that I see is when people bring old trust into me. Not only is the exemption up, now we have portability, so you don't have to equalize the estates.
Right.
We can simplify a lot of the planning that was done, which if it doesn't get simplified, they come in and they say, what do you mean my husband's share is in this irrevocable trust that I now have to file tax returns for, and things like that. So.
Right. That's great.
So certainly, it has been the biggest change, and is the need for everyone to review what might have been done in the past, because just as Jane said, you might have some unintended consequences that you're not expecting. So a couple other big things that came out in the TCJA was the qualified opportunity zone. It's was set up to encourage some additional investment into lower income areas of the country, but it also provides anyone that might have a taxable capital gain some way to reduce tax liability, and that can be in a trust. It doesn't have to be just an individual, but you are investing any portion of a gain that you might have. It is deferred. The tax on it is deferred. So, as an incentive to do this, the IRS or the TCJA has put in place is that at year 5 of your investment into this opportunity zone fund, you get a step up in basis, and then in year 7 you get another step up in basis. So at year 7 you have to recognize the gain, but you get a 15% step up in your basis. So you're saving a pretty decent amount of tax on that, depending on the size of the gain that you want to roll into this fund. You can do that with it. Most any financial advisor is going to have some idea or product of opportunity for this. So then the other great thing about this, so if you put your gain in at day 1, at year 10, if you've kept the funds in that fund for 10 years, any appreciation on the initial investment is tax-free as well. So it can certainly be a good opportunity to defer tax and then also save on some tax-free income. Of course, it's as the current environment of investments and things go, it might not necessarily be the best investment, but it's something to certainly weigh. In most cases that I've seen, there is some substantial tax savings if you have a large enough gain that it's worth locking that cash into this investment.
Yeah, I can just make a comment too. I think as of the end of 2019, there were over 9,500 opportunity zones, and similar to SRI investing or ESG investing for a long time, again, that's socially responsible or environmentally conscious types of investing. You had to sacrifice return, really. There wasn't that great of returns to justify kind of the altruistic type of investing that you would do in those things. But today, again, with many more opportunities, you get kind of a dual benefit, right, of helping a lower socioeconomic community, and then at the same time, so essentially it kind of works like a 1031 exchange for a while, right, where you're reinvesting back in, but eventually with this one, at year 10, you could have the potential to wipe out the capital gain altogether, which is pretty cool. And there's funds out there, so Opportunity Zone funds that actually will aggregate investments for you that are professionally managed. So yeah, it's actually a pretty good idea.
If you have rather large gains, there are opportunities for you to set up your own fund as well too, which certainly gets a little more complicated, but that is an option. A couple other things on the TCJA that I thought were going to be pertinent to our discussion today relate to the retirement plans, and then also the CARES Act and Secure Act expound on that as well. But the TCJA, they were put a few things in place, extend time to repay loans, and then also some of the changes to the IRA. Usually when someone comes to me, they're doing their taxes, we don't see that they've made an error by contributing to a Roth IRA until it's too late. So now in the TCJA, they're not letting you just go right back to the traditional IRA with those funds. So if you made more, there's an income threshold where you can't contribute to a Roth IRA anymore. You usually could just be able to recharacterize that to a traditional IRA, and they've put some barriers in place to do that. So that is kind of the summary of the TCJA that does relate to estates and trusts, and obviously there's a lot more to it. One of the biggest pieces of it that I've seen as a CPA that has benefited a lot of individuals is the small business owner. The qualified pass-through income deduction was a huge benefit, and certainly if that's something that you have seen or have a small business, then hopefully you have been able to take advantage of that as well.
Love it. I'll jump on to the CARES Act. A lot of these things are the result of the times that we're in. I mean, certainly the CARES Act was an attempt to provide liquidity, right? So there were many things that gave you more access to your funds with less penalties and much easier. And then obviously a ton of fiscal stimulus, right? So CARES Act, most of the time when you think of that, you think of PPP loans, and you think of EIDL loans and things of that nature, and unemployment benefits. So it was a result of a pretty serious time. So we could spend, many days talking about the beautiful thing of CARES Act. But so we're going to try to narrow it down just for the topic of maybe planning and certainly kind of estate benefits, right? So the first thing I had, let's see if I can use this thing here. Yeah, so just kind of a summary there. So coronavirus-related account distributions, again, more access to your money in a more favorable way during a challenging time. Required minimum distributions waived. We'll cover that real quick. Student loan payments deferred. The AGI limits, as Luke talked about, they expanded those, deduction capabilities in the TCJA, but now it's even more in the CARES Act. And so basically, you could access, right? I think you also have the capability of doing a loan from your 401k plan. And it used to be, 50% of the value up to $50,000. Now, again, it's even $100,000 in some expanded time periods of paying that back. You can also do a distribution. So even prior to 59 and a half, if you were, again, COVID affected, right? So you were somehow, whether it was employment, whether it was family, whether it was a sickness, you were COVID affected, you have access up to $100,000 of your IRA assets without the penalty that you would have normally had. And then they're going to do, I always looked at this as kind of like when they brought out the Roth, where they're going to give you time to pay the tax bill. So you actually have up to 3 years, right, to put the money back in, and then you have 3 years really to kind of pay the tax bill. Luke, talk about that a little bit, would you, about how
Certainly.
that tax bill may come?
This is similar if you've seen some of the hurricane relief that's come through the area. It's a similar benefit as that. So you have the opportunity, if you took $100,000, you have the opportunity of paying tax over a 3-year period on that money. If you don't plan on paying it back. There's a certain form you file with your tax return. It's going to spread that out where you're only going to have 1/3 of that tax, of the distribution to be taxable in the current year, which is certainly a great benefit, because if we're needing those funds, you don't really need that tax dollar to come out of there right away. So there's no withholding requirement either. So and most of the time, like I said, if you're needing that fund, you need it all. So this helps lighten the load of the tax burden. And then if you wanted to pay, if you recover, get some money, and you wanted to pay that back, then you can recontribute that money, and then if you recontribute it by the time you file your next tax return, there's no issue. But if you recontribute it in year 3, then you would need to go back and amend your tax returns to get that refund of the tax that you paid on those funds.
So a little bit maybe of a process, almost like when you do a rollover and you have the 20% withholding, you have that opportunity to put it all back in, but you may have to go back and refile to get the taxes that you prepaid, if that makes sense. But yeah, so essentially you could have had those funds, used them for 3 years, put them back in, had no penalty, had no tax consequence to that entire situation. So again, all of this as a kind of a COVID-related event for somebody to have access to their money, right? Required minimum distributions, right? And I think Jane will even talk about some of this expansion. But if you're in RMD status, that's required minimum distribution, and you're required to take that percentage out, they waive that for 2020. And so even if you took it out, you had the ability to put it back in by August. So if you took it out, and again, if they did some type of withholding on it, on your distribution, you could actually go and file and get that back. Right now, it would serve as a credit, right, to the IRS for taxes that are due. But if you put it back in, you could get those taxes back, again, when you file your tax return. So just another way of giving people access to funds during a very challenging time. Student loan payments, the same thing, right? So they initially deferred them for 60 days, then they postponed them to the end of the year. So set the interest rate to 0, no payments were due, and so again, just a greater access to capital to let people navigate a very, very challenging time. AGI limits. So as Luke talked about, again, with the TCJA, they had increased it from 50% to 60%. Well, now it's 100%, right? And so you essentially could wipe out your entire tax bill if you were charitably inclined. Think about the motivation here. When things are rough, charitable giving goes down. And so they thought, hey, this is going to be kind of like a dual purpose here. We'll encourage charitable giving again, and we'll give people some advanced tax credits and the abilities to do that effectively. So what this is doing is you actually have a carry forward now. So even if you gave more than your AGI limit, right, you can actually carry that forward for up to 5 years. So just trying to encourage charitable giving, which is actually a pretty good thing to do if you were going to do it anyway. Now it's a little bit more favorable. Even with yours, right? So the losses. So like I said, so many things in this bill for businesses, and so there's actually carry back now, even for, remember, losses that people had. They could carry them back for 18, 19, and 20. So yeah, many more things. The ABLE accounts we kind of talked about. Great account, just ABLE, you had to have had the onset of the disability prior to age 26. So you could still get an ABLE account after age 26. You just would have had to have had the disability happen prior to that time. And again, great account. Florida has a very good one. And those monies are invested. And as long as they're used for qualified spending, you can still qualify for government benefits. And then, at the same time, have tax-free earnings and returns on that ABLE account. It's a little bit about Roth conversion. Jane's going to get into a very good topic about, conduit, IRA, standalone trusts, and things of that nature. Well, we even talked about a little of this in the first panel with the Secure Act now limiting the amount of time that a beneficiary can take distributions from an IRA. That might change your plan, and I hope you're getting from these conversations that your estate plan is not static, right? It needs to be adjusted over time due to changes in your family, but also changes in the tax laws. So Roth conversions now may make a lot more sense. I was reading something the other day that 89% of the time, taxes are higher than they are today. 89% of the time. That's staggering. So pretty good indication that tax rates are probably going to go up in the future, especially as much fiscal and monetary spending as we've seen actually take place, right? So with Roth conversions, obviously you're thinking about accelerating a tax bill for you guys, right? If you're going to do this conversion to a time that's now, right? So you're controlling when you actually pay that tax bill. So just be conscious about when that's going to be, right? Is it more favorable now, or would it be more favorable later? And Roths in general, I always love the term, would you rather be taxed on the seed or taxed on the harvest? With a traditional IRA, you're going to be taxed on the entire IRA. With the Roth, you're just taxed on, again, the amount that you put in there. So if you're going to pass on assets to next generation, right, that might be a great reason, and all the more when we talk about the Secure Act, that, again, that might be a Roth conversion opportunity because you're going to pass on then a tax-free asset to them, right? So something to think about. Will my kids be in a higher tax bracket than I am? Am I going to be in a higher tax bracket later? Will the marginal tax rates be higher than they are today? I mean, all of those things kind of go into your planning of whether you want to do a Roth conversion or not. And there are great calculators, by the way, online that will calculate, the break-even point. If you do a conversion, obviously you're going to have to pay that tax bill now. And, how long is that going to take you to break even before it makes sense for you to do that? And again, kind of like Luke talked about earlier, if you're going to do a conversion, we always say pay the tax bill from outside of the IRA. You're removing a lot of its benefit if you're actually going to pay the tax bill from the account itself. Also, Luke talked about, you have income limits for Roth contributions. There is such a thing as what's called a backdoor Roth, where you can actually make a after-tax contribution to an IRA and then convert that to a Roth. And of course, there's no income limits for an after-tax contribution to a traditional IRA, which would also then give you the ability to convert it. The only thing you have to watch out for is what they call kind of the step doctrine or aggregation rules with regards to how that's rolled over. But if you have a planner, again, they could help you with sometimes the ways of that. So as long as you have earned income, right, again, you can continue to make contributions. And now, with both the traditional and the Roth, you can make contributions now past 70, which it used to shut that off. That was fun, wasn't it? I mean, that's Secure Act and the CARES Act. That's good. All right, we're going to jump into Jane for the Secure Act.
May I have the clicker, please?
Yes, please.
Thank you.
You need them.
So, as Mark said, we're now at the Secure Act, which went into effect on January 1st, 2020. It is actually the Setting Every Community Up for Retirement Enhancement Act, which comes up with Secure. It was signed by President Trump into law December 20th, 2019, became effective January 1st, 2020. And it does have some provisions that are going to affect your retirement assets. So your IRAs and those types of assets are affected by this act. The first thing it did is it increased the required beginning date for the required minimum distributions from 70 and a half to 72. It also repealed the maximum age for contributions, which Mark just mentioned, to traditional IRAs, and it allows for a penalty-free withdrawal of $5,000 for each parent in the year of a birth or adoption of a child. So if you have a child, you can take $5,000. But the biggest change that we're here to talk about today as it relates to estate planning is the stretch. So traditionally, you could leave your IRA to your children, and those children could stretch that IRA out over their lifetime. So that could, essentially, we're just kicking the tax down the road. And so it's a way to defer tax and pass that asset on while it continues to grow to your children. And a lot of times, a lot of estate plans that I see with clients that come in is their IRA is a lot of times the biggest asset that they have. And so that's another thing. When you're doing your estate plans, make sure you talk to your planner about, hey, this is an IRA, or so we know to plan for those appropriately. Because as I think Dina mentioned in the first talk today, that beneficiary designation is going to control over whatever your will says or whatever your trust says. It's that beneficiary designation. So that's just a little aside. But what this Act did, what the Secure Act did, was limit the ability for the stretch. So they've limited the stretch to a 10-year stretch. So if you are leaving your account to your children, it is now, they can stretch for 10 years, and after that 10th year, they've got to take it all out and pay whatever tax is left. And that applies to almost every beneficiary. There are certain classes of beneficiaries that doesn't apply to, so we'll go through those. The first is a spouse. The spouse still has the right to stretch out the IRA or to roll that IRA into their IRA and have essentially complete control over that and put off RMDs until they turn 72 and all those great benefits the spouse has. The other individuals is a minor child. A minor child doesn't have to start the stretch until they are of age, or if they are continuing with school until they're 26. So if your child goes to college, goes on to additional schooling after college, by the time they're 26, that's when that 10 years starts. So their potential for 36 is when that IRA would ultimately have to be cashed out. It also applies to a disabled individual or a chronically ill individual, or an individual who is not more than 10 years younger than the account owner. So if it goes to a sibling or someone like that. So those are the exceptions to the 10-year stretch rule. Now also keep in mind, if you don't have a beneficiary, or if you have an old beneficiary who is no longer living and that's going to go to your estate, then the 5-year rule is still in effect. So if you named your estate as your beneficiary, or you name a trust that doesn't qualify under certain provisions, that IRA is going to have to be paid out within 5 years. So I think if we talked a little bit about how the traditional rule was that you could stretch out over your lifetime. So many people in their estate plans would have, there's essentially two types of see-through trusts. There's a conduit trust and an accumulation trust. And we'll talk about both of those as we kind of go through the talk today. But many people in their estate plan had, if they had a trust, they would have a conduit provision in the trust. And what that conduit provision would do would give the trustee kind of the ability to control the funds, but the beneficiary would have to take the RMDs every year. So that RMD would be paid out to the beneficiary every year. And that stretch would be based on the oldest beneficiary of the trust. So if you had it going to your 3 kids and your oldest kid was 40, the stretch out would be over the lifetime of the 40-year-old. So we see a lot of these trust plans because there's some asset protection. There's some states don't, inherited IRAs are not exempt from creditors. Florida they are, but some states they are not. So there's some asset protection. There's also, in the case of a divorce, are they going to cash out this IRA and give half to the spouse and things like that some parents have concerns with. So we see a lot of these conduit trusts. But so now if you still have your IRA going through that conduit trust, what the Secure Act has done is once that 10-year is hit, the entire account has to be paid out to the beneficiary. So if you have set up a trust or your plan is that your beneficiary is going to just get a little every year, just what they need, that's no longer what's going to happen. Everything's going to be paid out at that 10-year period. So kind of an example looking at that. So under the old law, the RMD was determined using the beneficiary's life. So if you have a 25-year-old expected to live 58.2 years to distribute that account. And so they pay a little bit of taxes every year. And so now they only have that 10 years. So you can imagine that's really increasing the tax bill for your beneficiaries, and it can push them into a higher tax bracket, which could have other ramifications for them. So that's kind of the same thing. So what do we do? There's not a lot that we can't do to solve this problem, but one thing is, as I often advise is to name your spouse as the first beneficiary, because there's a lot that you can do, the spouse can do. If you have a non-spouse, you have to take a look at what are you more concerned about. Are you concerned about income taxes? Or are you concerned about creditors or the beneficiary themselves and just, wasting the money, or concerned that it's not going to be around for the grandchildren to have a benefit? So you kind of have to look at, well, what are my main concerns with these funds? And so one of the things you can do is, as Mark was talking about, is think about converting those funds to the Roth and paying the tax now, which could help your beneficiaries immensely as it goes on to the future. Another, and I don't know if you had anything to add over, you kind of went over it.
No, I mean, like I said, we're always worrying who's going to pay the higher tax, right? Because you're trying to minimize that bill either for you or for the next generation. And then, you're doing that strategically, right? So it's not an all or nothing kind of thing, and it could be some that you do piece by piece. So you're managing kind of the marginal tax bracket, right, that you're in. So maybe do conversions up to a certain point. And again, you're doing that for the benefit of taxes, not necessarily you, right? It could be disadvantageous for your spending right now, right, in paying that tax bill. So, but if you're, like you said, whatever your goal is the goal to minimize taxes, or is the goal to actually provide creditor protection for the children or limited access to the children? Yeah, I mean, some of our kids, we may not want to dump that much money on them in a single tax.
So if the option is that you don't want to necessarily have your children inherit all this money in the 10-year time frame, then you can look at an accumulation trust. And an accumulation trust is also a see-through trust by the IRS standards, and it's a little bit more complicated than your traditional conduit trust. But what you can do is accumulate those distributions, and the ultimate payout stays in the trust. Now, the issue that you have with here is what Luke touched on earlier, and we've kind of been talking about all along, is the tax bill. And so as Luke mentioned, if that income stays in the trust, that's going to be taxed at the highest tax bracket if it's over the $12,600. So that can be a huge tax hit, and especially if your children are in a lower tax bracket. So that is a huge consideration. There's also some other issues you have to look at, like you can't have a charity named, and there's some other issues with accumulation trust. But I've seen a lot of situations where I have clients that say, look, my child is not responsible at all, and I do not want them to ever get a lump sum payment. I want to make sure that there's money there for the grandkids if they need it for college and all these things. So they say, I don't care about this big tax hit. And so that's a consideration you're going to have to make for what's best for your family if you decide to go with a standalone retirement trust. And typically, I would recommend a standalone retirement trust instead of doing it through your living trust. Mainly, it just simplifies things, so we're very clear on what the retirement benefits and how those are handled versus do we look at these other provisions of the living trust and try and apply those to the retirement section. So that's one way to handle the stretch. The other thing is just simply buying life insurance and an irrevocable life insurance policy to pay that tax, so to help your kids pay that tax, because like we talked about before, it could bump them up into a higher tax bracket for everything and really create some hardships on them. So that's
Yeah, I would just say something too from a planning note. For those of you that don't need the RMDs, right, the requirement of distribution, some of our clients actually take those proceeds and they're actually paying for a life insurance policy, right? Mm-hmm. So it's distributions from that that now are actually paying the tax bill, in the future. And of course, life insurance proceeds are tax-free, right? The death benefit.
Yeah, and if you put if you purchase that life insurance in what we call an ILIT, an irrevocable life insurance trust, as long as you have that for 3 years, that all passes outside of your estate as well. So as Luke was talking, right now our exemption rates are really high. So we have the 11.2 index for inflation, but they're set to go back down, and who knows with the election what's going to happen with those rates. So it's something where we could be back in a situation where it's 3 or 5 or those lower exemption amounts. And then the other option to consider, again, if you're charitably inclined, is a charitable remainder trust. And essentially this will allow, if you leave your IRA to a charitable remainder trust, your beneficiaries can get certain amounts paid out to them over their lifetime, but the remainder is going to go to charity, whatever's left in that account. And this is, again, is for those that are charitably inclined or don't think their beneficiaries need all the money, because they're going to get a much smaller distribution usually than they would have had you left it outright to those individuals. So with all this, I guess the take home from my perspective for my presentation is to talk with your advisors, check your beneficiary designations, and understand what they say and what that's going to mean. So if it's, you name your spouse and then 3 kids, then each child's going to get their own inherited IRA, and it's going to be stretched for 10 years, unless they choose to cash it out right away. And so Mark and I were talking about this, and one of the things to keep in mind too is that they don't have to just take the required minimum distributions for the 10 years and then take everything. They can kind of take it out over those 10-year time frames. So it's not a huge hit at the end, but it's still going to be a pretty big tax hit when that 10 years is up. And so then also you want to look at any changes in your circumstances and make sure that everything that you have, all your beneficiary designations, your estate plan, everything reads together and works together in the best possible way for what you want to achieve. And with that, does anyone have any questions?
How are we doing on time, Drew? Is that right? The charitable remainder trust, too, is a pretty cool option because obviously you're going to get a tax deduction for the present value of the future gift, which is good. So people can use them. Let's say you had a farm in the family that had a very low basis and was producing no income. Again, you could put that into the charitable remainder trust, sell that asset now, avoid the capital gain, and buy something that actually is producing income. Because like Jane said, that trust now is going to produce income for your lifetime, and then of course when you pass away it's going to go to the charity at that time. So has other benefits besides the charitable inclination.
Yeah, and so you can use the charitable, as Mark was saying, you can use the charitable remainder trust for any asset. It doesn't have to be an IRA. It can be, like you said, an asset with low basis, and you get rid of all that appreciation out of your estate. So it is a pretty neat tool if you're inclined to give to charity and still get that tax benefit.
No questions?
Oh, stop it, please.
All right, thank you, guys.
Thank you.
We're going to take a 15-minute break before we move on to our third topic.
It's the
I moved this table that was here. I mean, I basically spent the first 30 to 40 minutes just saying this. And I need, especially once I tap into how the house's network, TV, everything else. And luckily I
Is it really? Right now? You can hear everything?
nobody ever put on. I should be.
Yeah, I was thinking.
Yeah.
Yeah. You know where it's at? Yeah.
We did start a little late. Well, half a day, I use a half day vacation. Come at it. Just want to make sure you
Do we know how we're gonna cue these slides, like forward, reverse,
I think this
start,
is our clicker. Yeah, and Mr. RJ has our presentation. And I think the bottom button is our clicker for forward, and I think the middle one might be back. I could be wrong. I don't know.
Hey, I'm here.
Good morning.
Good morning. Oh my goodness, I should have asked y'all yesterday. I haven't been to this campus very often. I've only gone to the plays over at Maddie Kelly. I should have asked you for directions. I took a 30-minute stroll around the whole campus trying to get here.
It's come a long way since it was Okaloosa Walton Community College.
Yeah,
And it continues to grow.
And it really has.
No,
We're
it's a
proud of
beautiful
it.
campus, and I
Yeah.
think
Oh, yeah.
I've seen all of it now.
Yeah.
So he said the videos aren't going to play.
All right, welcome back, everybody. We're going to move on to our third topic, estate planning for blended families. And our presenters are Mr. Drew McDowell, financial advisor with Arbor Wealth Management, Mr. Hugh Ross, financial advisor with Polaris Wealth Management, and Ms. Christine Sutherland, attorney with Dunlap Shipman.
Hang on, guys.
Well, great. Good morning. We're here to kick off this next session. We're going to talk about estate planning for non-traditional families. So here's our agenda, and you guys can see that. We're going to talk about, hey, what is that traditional family nowadays? And then we're going to talk about what that looks like, some traditional family by the numbers. And then we're really going to focus our time on talking about what we call non-traditional families and why estate planning for those non-traditional families is so important. And then we'll wrap up talking about the different types of non-traditional families and some unique planning situations. So I am very fortunate to be here with two of my esteemed colleagues. To my left, Christine Sutherland, she's an attorney, but you get a twofer. Christine is an attorney with Dunlap Shipman. She graduated with her law degree from the University of Alabama, my nemesis in college football. They just beat us really bad this past weekend. And then she also is not only an attorney, but she's a certified public accountant. So you get a twofer with Christine. To my right, Mr. Drew McDowell, you get a twofer with Drew. Drew also graduated from law school, earned a law degree, but in addition to that, Drew is a certified financial planner. So I am with two young, esteemed professionals, and I am proud to share the stage with them. I'm Hugh Ross. I am also a retired Air Force guy. Spent 20 years on active duty in the military, and then I started my second career in wealth management. I had the pleasure of attending school at the Air Force Academy, but because I grew up in Georgia, I'm a Georgia Dogs fan. So again, I have to sit with a lot of folks from Alabama today. So let's keep moving. So what is the traditional family? If you're my age or older, and I'll give folks the Reader's Digest, I'm 58. So if you're my age or older, you recognize this guy. That's Leave It to Beaver for all the youngsters in the audience that don't know. But when I was growing up, the traditional family was husband, wife, 2 kids, a dog. So for Beaver here, it was Ward and June, Cleaver, and they had their sons, Wally and the Beeve. And that's what most folks my age and older think about when we think about planning. We think about the old traditional family, husband, wife, couple of kids, if you're fortunate, grandkids, and it was all sort of neat and clean. But you don't have that so much today. So let's just look at some numbers. So if you can wrap your head around this, things are changing. So marriage rates for folks born in the baby boomer generation, those are the folks born 1946 to 1964. On the front end of that, about 91% of the folks were married. And there are a lot of reasons for that. But if you think back to the folks on the front end of that, that was coming out of a time when most women either didn't work outside of the home, they were homemakers, or the opportunities in the labor market weren't nearly as expansive as they are today. And so their parents taught them to, go to school, get an education, but look to get married so you would have somebody to help support you and help you start a family and raise children. By the end of the boomer generation, marriage rates are down to about 87%. Then when you cross over into what we call Generation X, those are the young folks who were born between 1965 and 1980. Marriage rates had dropped down to, again, 75% or 80%. And then by the time you get to the millennials, folks born between 81 and 96, marriage rates continue to drop. And those are projected to be about 75%. So things are changing. Not only are the marriage rates dropping, but divorce is going up. So the divorce rate today for folks getting married is about 50%. For those people who get married a second time, goes up to 50, so jumps up to about 60% for a second marriage, and then for a third marriage, it jumps almost to 3 out of 4 get divorced again. And there are lots of reasons that folks speculate, psychologists speculate for why that happens. Folks who've gotten divorced once, some folks say, well, they've been through that, and they recognize the signs when things aren't going as well, so they're not going to hang around and tolerate another bad situation. Some folks say they are better established the second time around, so they don't fear getting out on their own. Lots of reasons why, but the reality is divorce is more prevalent now. Today we have same-sex couples. So when my grandparents were growing up, there was no such thing as a same-sex couple. When my parents were, raising a family, if there was a same-sex couple, you didn't know about it. Well, things are changing. So today, same-sex couples, about 61% of them are married, and 16% are raising one or more adopted children. So that, again, traditional family that a lot of people visualize doesn't exist to the same degree it did a few years ago. We also have cohabitating couples. So 59% of the adults age 18 to 44 have cohabitated with a partner. We have people today who are intentionally single parents. So unwed mothers have been decreasing since 2008. However, among women ages 35 and older, some are choosing to be intentionally single parents. So I don't know what's driving all of that phenomena, but I have 2 older sisters, and one of my older sisters is a physician. She's been busy in her professional career, and she just never got married. So you see that more and more. And then another phenomena that's more recent, but is, again, a rising number, is divorce among Americans age 50 has doubled in the last 25 years. So the people we think about when we think about traditional estate planning, we have to set that aside, because today we have a lot of non-traditional families. So there are a lot of benefits that most people, when they're thinking of that traditional family, whoa, what's going on?
We're good. A little too far.
That's weird, that's weird.
Something magic is happening.
You have some automatic timing going on here?
Yeah. We'll go back. There we go.
We want to go backwards.
Let me help you.
Thank you.
Yeah, so
Thank you.
when most people think about traditional families, they are assuming a lot of the things that are listed here. So most folks know that there are advantages in terms of Social Security benefits for married couples. As a married person, you can't be compelled to testify against your spouse. You can decide, I don't want to testify against the spouse. You get the benefit of being able to file a joint tax return. You can do joint homestead filing. You can do a joint bankruptcy. One of the most important things that a lot of people overlook is this idea that if you're married, you have benefits under the health care laws, HIPAA, and you can show up and see your spouse in a hospital and make decisions that you don't have if you're not married. And then the idea of intestate inheritance. For a married couple, transferring assets to your spouse is much easier than if you're a non-traditional family. So what we're going to do is I'm going to turn it over to my esteemed colleagues and let them talk a little bit more about the non-traditional family. I'm sorry.
Thank you, Mr. Hugh. Okay. So in preparing for today, by the way, very quickly, I talk fast, but I'm not a fast talker. So I apologize in advance if I go too fast. I'm sorry. That's a joke. It fell flat, but that's okay. Basically, when you think about the non-traditional family, we have to start thinking about examples that we can all relate to. The slide that you see here, what should be playing is the introduction to the ABC hit sitcom Modern Family, in case you're curious. This is actually the end screen of the YouTube video, so we're stuck on Mitchell and Cameron and their daughter Lily. And you might be saying, why do we want to talk about a sitcom when we talk about non-traditional family estate planning? Well, the Pritchett family, which is the family that this sitcom is based on, is the best example of multiple opportunities for non-traditional estate planning that one can think of. And this television show has been on since 2009, recently just had its finale last year. And in case you're curious, in 2015, when the Supreme Court made same-sex marriage legal, in 2015, the season finale was the same-sex marriage of Cameron and Mitchell. So in real time, we see art imitating life, and we're able to draw valuable estate planning lessons from the Pritchetts. So up here is the modern family tree, and this does not include people who have married into the family. So I want to go over this very quickly. Ed O'Neill, everybody remembers Ed O'Neill. He is played by Jay Pritchett, who's the middle head of the family tree there. So Jay's first wife was Dee Dee, and he had 2 children with Dee Dee. He had Mitchell and Claire. Claire is married to Phil Dunphy. If you're familiar with memes, everybody loves the Phil. Good job. He's such an encouraging dad. Claire and Phil have 3 children, Haley, Alex, and Luke. I promise there will be a reason why we're going over the family tree momentarily. Mitchell and Cameron, legally married in 2015, have adopted Lily, a baby from Vietnam, and then Rexford Tucker Pritchett later on in the series. Jay, of course, got divorced from Dee Dee, and later on in life decided to marry Gloria Delgado Pritchett. Gloria is an immigrant to the United States from Venezuela. She is married, was previously married to Javier Delgado. They had one lineal blood descendant son, Manny Delgado, who is later adopted by Jay. And then Gloria and Jay have a natural born child together whose real name is Fulgencio, but I can't spell that, so we're going to go with Joe. Okay, you've done the family tree. So how, what estate planning, non-traditional estate planning items can we pull from this family tree? Well, first, Jay got divorced from Dee Dee. So in his original estate plan, he probably named Dee Dee as the primary beneficiary of his estate. That is valuable to know because now Jay is married to Gloria, and Gloria might want to be the beneficiary of some of Jay's estate. But then, of course, we have Claire and Mitchell, who are Jay's children from his first marriage, who Jay might want to benefit from his estate should he pass unexpectedly. So how do we as estate planners draft trust documents or estate planning documents that take care of Gloria and their two minor children, Manny and Joe, while at the same time making provisions available for Mitchell and Claire? To further complicate things, does anyone here know the name of Jay's business, what he does for a living? It's the best thing of all time. He knows. So that's Phil is the realtor. That's a good guess, Mark. No, Jay owns Pritchard's Closets, which is a custom closet and blind maker. Their #1 competitor is Closets, Closets, Closets. If you don't think that's funny, comedy isn't for you. Jay owns a business. He is the 100% owner of the business. Claire, after having no career, raising a family for a few years, has decided to come back and run the business for Jay. Now, does Gloria get equity in the business that Jay owns if Jay were to pass? Or does Claire get the equity in the business that Jay owns if Jay were to pass? Because Claire is the one running it for Jay now that he's retired and playing golf. These are all estate planning questions in a non-traditional family that is more common than you would think. Because, as Mr. Hugh just mentioned, 50% of the marriages in the United States end in divorce. That number jumps for second and third marriages. We have to make provisions for children from first marriages, children from second marriages, perhaps even children from third marriages. And fun factoid, in case you're curious, you can see Manny there on the right-hand side of your screen. Manny is the lineal blood descendant of Gloria and Javier, but because the Pritchards live in California, which is a second parent adoption legal state, Jay is able to legally adopt Manny. That is not the case in all 50 states. So you might think, hey, Manny was not born in the United States. He's not a United States citizen by birth, but he becomes a citizen through his mother. The planning opportunities are endless. So when you're looking for non-traditional estate planning opportunities, look no further than reruns on Fox. So moving on, a couple of different types of non-traditional families. A lot of people, when they think about non-traditional families for estate planning purposes, they might say to themselves, well, my family, we don't have any same-sex couples in my family, so I don't need to worry about non-traditional estate planning. I would counter to you that statistically is probably not the case. Number one, and Christine is going to take over a couple more of these, but I want to just go through them very quickly. Number one is divorced couples. You might be saying, like, that's an oxymoron. It is an oxymoron, but it happens more than you would imagine. Two people, whether they be same-sex or opposite sex, get married. A few years later, they decide they don't want to be legally married anymore, but they cohabitate. That is incredibly common these days. Or they maintain common financial interests because they have children together. So they don't get remarried to anybody else. They probably want to benefit each other in some way in their estate plan. But as Mr. Hugh mentioned, the default benefit of being married means you get some intestate protection if you are married, but if you are legally divorced, that has been severed. So estate planning would be necessary there. Cohabiting couples. Amongst millennials, this is probably the most fast-rising cohort of people that need complex estate planning. If you are not legally married, again, the state does not really want to give you a lot of freebies. So you do need to make proper estate planning goals there. And in addition, if you have children together, but you're not legally married, so a cohabiting family there. Blended families, everyone knows where we're going with this, and Christine will take that momentarily. Obviously, same-sex couples. Intentionally single parents are incredibly interesting. This is becoming more and more common, obviously, with the rise of in vitro fertilization, as Mr. Hugh mentioned. Single motherhood is on the rise amongst women who are over the age of 35 in the United States. And by the way, all of our statistics came from the Pew Family Research Council, in case you wanted to Google them. So those intentionally single parents, you know, there are documents that you might not think about that would be incredibly powerful for a person that doesn't have a spouse who can make medical decisions for them or make financial decisions for them should they become incapacitated. And I want to jump back very quickly. This wasn't a part of my plan, but I'm going to do it real quick because I can. And I spoke too soon. Oh, go back one? Okay. Okay, very quickly. We are here. We're watching this online digitally. Thank you all for tuning in at home. We really appreciate you guys being here in person as well. There is an estate planning document that I guarantee you that very few people have drafted, that the lawyers in this room will say you need to have drafted. And we are here on a college campus. It is incredibly powerful. Haley, Alex, and Luke in the series all go off to college. They should have living wills, durable power of attorneys, and medical directives. They should have those documents in place. We're here on a college campus that has been shut down by a global health pandemic. There are students in the United States who have been hospitalized who live 10 states away from their parents. Their parents need to have those documents so they can fax to the hospital and say, yes, please, I need to be able to talk about my child's care, especially if you have a blended family, a cohabiting couple, a divorced family where the child's last name may not be the same as yours, but you are that parent's legal guardian or that child's legal guardian. Those are the types of kind of evolving estate planning concerns that we need to think about, and very few people think about documents for young children. So I think that's incredibly interesting. And then, so I will show up. The last one, though, bachelor spinster by choice. Obviously, this is an interesting estate planning opportunity because you have to say, hey, you are accumulating assets. To whom or what are you going to leave these assets to? And should you become incapacitated, what trusted person do you have to take care of you? Those are all, you know, I guarantee you, if we think in our Rolodex of family relationships and people we know and love, surely everyone here has a friend or family member that falls into one of these categories to whom non-traditional estate planning would be very important. So without further ado, I will be quiet and turn it over to the expert, Christine. We're going, yeah, down, sorry.
Bingo.
Okay, so I'm going to talk briefly about blended families. We have the Brady Bunch. Everybody in, I believe, every age group knows about the Brady Bunch. And, you know, I think probably back when this show was filmed, the Brady Bunch was maybe an anomaly because everybody was the traditional family. I do estate planning for clients of all age groups and varieties, and in this day and age, the yours, mine, and ours situation is increasingly more common. I guess the good news for the Brady Bunch is there are estate planning, there are documents, that anything that you want to accomplish through estate planning generally can be done. You just have to have a candid conversation with your advisors. The bad news for your non-traditional families, even though they are becoming more of the norm, is that things are not quite as easy for the Brady Bunch scenario as it was for the Leave It to Beaver family, because the laws are just not set up. The laws haven't been enacted to protect this family as much as it has the traditional family. So estate planning for your blended families just becomes even more important than it is for everybody else, just to make sure that you let your advisors know what it is that you're trying to accomplish, and you have candid conversations with them. Nobody benefits if you come to your advisor and want to act like your family is perfect or your non-traditional family is the traditional family. You know, everybody needs to be on the same page and know exactly what you're trying to accomplish. So just a few kind of thoughts and ideas for you guys. There isn't any, as I believe some of the earlier speakers alluded to, there's no black and white, one-size-fits-all plan for every family, even traditional families, but especially not in the case of a blended family. So for your blended family, your plan is going to be very unique to your particular circumstance that you're in and your particular goals that you're trying to achieve. But just a few issues that run up in blended families, and Drew alluded to them with the the family tree for Modern Family. I'm not as much of a Modern Family guru, so I don't know all the names. But basically, the tough situation that you're placed into when you're in a situation like this is you know, you have married your second spouse or your third spouse. Obviously, you love that spouse and you want to protect that spouse. On the flip side, you have children that are not your spouse's children. So your spouse, their primary objective is to protect their children in some situations. So you're kind of stuck in the situation where you want to make sure that both your spouse, your biological children, and your stepchildren are all provided for, and how that looks for each family is a lot different. As Drew and Hugh both alluded to, you know, if you're in this blended family situation, you know, most of the time you have been divorced previously. So you may have had estate planning documents that were drafted prior to your divorce, and by operation of law, any devise or anything that you've named for your ex-spouse is going to be invalidated by that divorce. Well, in some situations, that's a great thing. In some situations, you know, if you and your spouse are still trying to provide for your children, then that's not what you intended, and a lot of people don't know that that's how it works by operation of law. On the flip side, some people say, okay, well, I'm divorced, so nothing that I gave my spouse, nothing I named my spouse in is going to be valid, and that's not necessarily the case either. So at the outset, at the time of the divorce, you need to meet with your financial planners and advisors and see what kind of changes need to be made to make sure that your plans reflect whatever it is that you and your ex-spouse agreed on. Then going forward for the blended family, if you don't have any estate planning in place and you have a spouse and you and your spouse have children from prior marriage that are not your children together, the intestacy statute is going to give your spouse 1/2 of your estate, and then your children are entitled to the other half of your estate. Well, in this case, you know, you may have intended to provide for your stepchildren. Well, your stepchildren, since they're not your biological children, are going to receive nothing. On the other side of that, you know, your spouse may have received a hefty settlement from his or her prior divorce, and you might not think that your spouse needs that whole entire half of your estate. So it's very important that you have these conversations with your spouse and your financial advisors just to determine exactly what it is that you're trying to accomplish. In most situations for the blended family, again, not all, you know, it's even more beneficial to set up a trust of some sort than it is, you know, a trust for a traditional family. Generally is going to help you avoid probate. It's going to set some restrictions maybe on distributions for your children. Well, in the case of a blended family, you know, that is probably the most likely or the best tool to be able to provide for your spouse, but make sure that your children and your stepchildren are still provided for at the end of the day. I believe Drew is going to talk about some more of the issues that face single families or single parent families. So, you know, in the case of a blended family, you do have a spouse, so you do have somebody who automatically, by operation of law, is going to have access to your health care records and other things like that. So while a living will is important in a blended family, it's not as vital as it is in some of the you know, single parent situations, which I believe Drew was going to touch on.
For sure.
Here you go.
Thank you very much. Thank you, Mr. Hugh. Okay, so getting off of the Brady Bunch. Oh, by the way, so obviously the media not working is not as ideal as possible, but I do want to, okay, quick crowd reaction, yell it out when you see it. What, one more slide forward, come on, let's go. What movie or television show does this clip come from? Oh, no. Oh. It was so fast. We're fighting, all right.
Each other.
We'll go one forward, please, sir. And one more forward. Okay, what does this come from? Cinderella. Why is Cinderella important for estate planning? Cinderella's dad did not have a Q-tip trust. Cinderella's dad owned the inn. He owned the nice building that Cinderella was able to live in. And then Cinderella's dad marries the evil stepmother, who you see right here. And she has the 2 evil stepdaughters. And they make Cinderella night and day Cinderella. They make her clean and cook and everything. And she has to live in the attic, and the daughters get, all the benefits of being the evil stepmother's daughters. If you had a Q-tip trust, which you're not supposed to stick in your ear, but you Google Q-tip trust, that would be an opportunity for Cinderella to have beneficiary ownership of the house that technically should be hers because it was her father's before her. And instead, we get the evil stepmother who makes her do all of the work and get none of the benefit. But eventually, we all know it works out well for Cinderella in the end. But proper estate planning would have made this story not as interesting for Walt Disney. So we'll kind of jump around a little bit, I guess. We'll talk about same-sex couples very quickly. Prior to 2015, as most everybody knows at home and here as well, same-sex couples provided a lot of very complex estate planning opportunities, mainly because they are not recognized by our state intestacy statutes. Now, obviously, now that the Supreme Court has recognized same-sex marriage, a lot of the traditional sort of who gets my stuff if I were to pass away, who has legal visitation rights in the hospital, who would be the default person to make financial or medical decisions, that has kind of all been taken care of, thankfully, which makes everyone's estate planning lives easier. But there are still some concerns, obviously, namely when you're talking about same-sex couples that are raising children together. That's something that should definitely be managed, and that's one of the biggest concerns from a planning standpoint, because again, currently, we treat same-sex couples as if they are opposite-sex couples for statutory purposes, but our laws have yet to kind of really catch up when we're talking about children that are being adopted. Intentionally single parents, incredibly interesting as well. Love talking about the opportunities there. If you are divorced, or if you just choose to have children on your own, whether you adopt them or have them naturally if you're a female, then you'll be able to obviously have a lot of documents for yourself, but also documents for your children. And one of the things we always recommend, if you are a single person with children, you need to meet with an attorney to talk about who is going to have legal guardianship, who's going to have control over your children should you pass or become incapacitated, and then who's going to have control over your assets should you pass or become incapacitated. And I think a lot of the lawyers in the room will shake their heads in agreement. Sometimes that doesn't need to be the same person. Sometimes you need to have someone who's the financial head of household, and sometimes you need to have someone who's the care head of household. A lot of times that happens to be the same person, but checks and balances work in the government. It works at home as well. One other thing to think about is obviously if you do pass unexpectedly, you're not able to make those discretionary control decisions over your money. One, our favorite acronym for lawyers to throw around is HEMS, Health, Education, Maintenance, and Support. Obviously, health, education are pretty simple and self-explanatory. Maintenance and support open to a little more interpretation. Who do you give that HEMS power for distributions to your minor children or even children that have gained the age of majority? Who has that power, if at all? And then, of course, age of inheritance for children. I'm sure every lawyer in this room can tell you, and financial advisor, CPA, it doesn't matter. Everyone can tell you about instances where a client has come to them and said, I love my children so much. They're the best thing since sliced bread. I do not trust them with a dime of my money. And, number one, so who's doling out that money? Who makes the decisions? Who has to have the legal responsibility to get sued if the child doesn't like that decision? And then do they get access to, the full principal of the money, if ever at all? Those are all things that need to be discussed, especially if you don't have a spouse to fall back on should you become incapacitated or pass unexpectedly. Am I going over your stuff, Christine? Do you want me to keep going? Keep going? All right.
Keep going.
Families with non-marital children. This is becoming more and more popular and prevalent in our society. I mentioned second parent adoption. That really came out of the Supreme Court legalizing gay marriage and same-sex, I should say, same-sex marriage Even unmarried couples, so cohabiting couples can legally adopt each other's children. That would not require that the legal rights of the child's natural lineal blood parent be extinguished. So a lot of times in our planning scenarios, people think, let's see, a husband and wife have a child, they get divorced, and then the wife decides to get remarried. The second father can legally adopt that child, and it does not require that the actual lineal blood father of the child have his rights be extinguished. That is not the case in all 50 states. It is legal in Florida. It is not legal in Alabama. Definitely something that's interesting, because when you think about it, you may, as the second parent, want to include that child in your estate plan, and so you legally adopt them. They get all of the intestacy protections, so the statute treats them as if they're your lineal blood descendant. But if you don't legally adopt them, they have no rights under your estate plan. And you may still love that child very much and want to provide for them, so that requires some additional estate planning work. Bachelor spinster planning, it's a terrible term. I can't, anyone comes up with a better one, holler it out. In short, we all have to think about the best decisions we can make for ourselves. Again, I'm not a coronavirus alarmist. I just think it's a good example, an opportunity for us to think, if you are a single person, hey, maybe it's time to think about who is going to have my designation of healthcare surrogate. Because, goodness forbid, something bad medically happens to me. I want to know that my trusted loved ones are making decisions for me, and I don't want there to be delay. I think we can all agree that kind of the worst case scenario is you go to the hospital and you've got competing parties saying, well, I'm Drew's mom, and Margaret is watching at home, hey, Mom. See, that's funny again, guys. This doesn't have to be serious. Mom wants to come in and make decisions because that's what moms do. My brother, spouse, other people might want to come in and make decisions for me. So we want to make sure that we have a clear line of succession for making those healthcare decisions for single persons. And obviously, since joint ownership of property is not an option, if I own a house, which I do, I want to make sure it passes to who I want to get it. A trust makes the most sense, because obviously I don't have another person who's just going to, by default, get my stuff and make decisions for me. So that's an interesting planning technique there. We can, you want to go back to blended families again? Yeah, let's do that.
I did have something to add on the bachelor and spinster planning. Let's see, we'll go back. Well, we don't need the slide anyways. A lot of bachelors and spinsters think, okay, well, I don't have children, I don't have a spouse, I don't really have anybody to take care of. I'm fine with the way that my estate would pass through the intestacy statute. I will say, in my experience, I believe Jim's going to talk about will contests and trust disputes after this. In my experience, these are the estates that are most likely to have, or a lot of cases, have the challenges because there isn't any clear-cut person. There isn't, this is my spouse gets everything, or my children get everything. You have these distant relatives who've never been involved in Aunt Sue's life, all spending all of this money to fight over something that they didn't even have any idea that they were possibly entitled to. So the bachelor and spinster planning, even though you don't have a spouse or children, is vital so that the courts and the attorneys and the financial planner, or not financial planners, attorneys and experts don't end up taking all your money in a will contest. You want to make, if you don't have anybody in particular that you want to leave things through, there's so many charitable devices or instruments to facilitate charitable giving. So you can't say enough about how important planning is for these couples. We will, or not these couples, these individuals. I guess we'll go back to blended families.
Sure, very quickly, yeah.
Okay.
I'm sorry, I apologize. I think we skipped. We went too fast, or I went too fast. Like I said, talk fast, not a fast talker. Okay. I just think this is really interesting. When you think of the Brady Bunch, think of our blended family planning opportunities, okay? I think they lived in California. Was the show was set in California? California recognizes second parent adoption, so we know that Mike and Jan can adopt all 6 of the kids. They can be legally each other's children. That's not that big of a deal, but one thing to bear in mind is what sort of estate plan do the Bradys have to have in order to make sure that all 6 of their children share in the assets should, goodness forbid, something bad happen to one or both of the parents. You know, usually when you're talking about blended families, you're not talking about a yours, mine, and ours situation. Usually it's, I have children from my first marriage, maybe the other spouse doesn't. And so then you get into, well, what family assets, like the family farm, or, you know, my grandfather's antique shotgun. What do I want to keep in my lineal bloodline, even though I love my adopted children very much, or I love my spouse very much? I don't want the family beach house that Laura mentioned. I don't want that to go to a different line. I want that to stay in my family. All of that can be done very, very easily through attorneys that practice estate planning law. I don't do that anymore, so I'm saying it's so easy. And so, yes, all of that can be accomplished very easily. So I think we could we do questions. Yeah, if anybody
We'll
has
do
them.
some questions, but
Yeah.
let me make one quick point, just to take us back up to the 30,000-foot level. Whether it's a traditional family, a blended family, it doesn't matter. Remember that estate planning is really about people. Forget the stuff. It's about people. And it's an opportunity for folks in all those categories to think through 2 critical questions. What do I want to happen if I become incapacitated and I can't make decisions for myself? Okay? So, unfortunately, with COVID, we've had young and old go in the hospital, be on ventilators, not be able to speak for themselves. Somebody has to step in. And in some cases, that somebody is somebody who knows nothing about them, because the people who do know something about them aren't there. They're not in the same geographical location, and the people in the hospital don't know who the next person is, and that person can't speak for themselves. So that's a critical question, whether you're part of a traditional family, you're single, is what do I want to have happen if I become incapacitated and I can't make decisions for myself? I can't speak for myself. I can't handle my own personal affairs. And then the second question is, now if I pass away, or when I pass away, what do I want to have happen with my stuff? And there is no rule that says it has to be a certain way, unless you die without ever having done any work to decide that for yourself. That's when the state laws kick in to say, okay, here's how your stuff gets divided. And that's why we offer these estate planning days, to try and encourage people to just stop and think through. Don't get overwhelmed with all the techniques that we talk about. Don't get overwhelmed with all the tax stuff. There are professionals who can help you, but you have to decide for yourself, what do I want to happen, and who do I want to speak for me if I can't do it myself, and then what do I want to have happen with the stuff I've accumulated in my lifetime when I pass away, whether that's unexpectedly or when I'm 150. So with that, let's go back and take any questions anybody might have. Okay.
I kind of have a question.
Yeah, shoot.
And I don't know if it's going to come out right, but we're a blended family.
Sure.
His and mine. And you said stepchildren have no legal rights. Okay, I can understand that, but say he's got 2, I've got 1. Does that mean if he passes away before me, then his stepchildren don't have any rights, or is it only my stepchildren doesn't have any rights? Does that make any sense at all?
It's a great question.
Makes perfect sense.
Mr.
Yeah.
Talk to.
Yes.
Repeat the question to the answer, please.
Okay. So the question, I'm gonna try to summarize and restate it, is basically there's a blended family in the audience. The question is, I had said stepchildren didn't have any rights to inherit. So the question is which stepchildren or which children do have rights to inherit. So I guess at the high level, if you have any sort of documentation, a will or something in place, that was only stepchildren don't inherit by virtue of law. So if you have any documents in place, you have a will that says, I give to my 2 children and my 2 stepchildren X, Y, and Z, then that eliminates the problem entirely. If you don't have any estate planning in place, say you guys, you have bank accounts or you own your house as tenants by the entirety as husband and wife, well, then the survivor of you is going to get the whole entire estate, and then only the survivor of the 2 of you, their children, would by operation of law be entitled to receive any assets of the estate, unless the survivor of you then goes back and does some estate planning and says, no, this is not the way that we wanted it to work. We want it to be split between the 4 children equally. Then that can be done. But if you don't have anything in place, and you have things set up to where, if you have beneficiaries named, like on a bank account, and you've named your spouse, then everything is going to go into your spouse's estate. If you don't have any beneficiaries named on anything, you don't have any estate planning in place, the intestacy statute would give 1/2 of your estate to your spouse and 1/2 of your estate to your children, and then your stepchildren wouldn't be entitled to get anything until their biological parent passed away.
And that's a great question. And to kind of take it a step further, like I think the biggest fear that a yours and mine family has is, goodness forbid, one of the spouses passes, and then there's it's a terrible term, but like a nursing home marriage that everyone has seen before. One of the very first things when I got my legal license, I had a 91-year-old man come to me and said, I need a prenup, I'm getting married tomorrow. And I said, oh, that's awesome, congratulations, how long have you known her? And he said, 3 weeks. And so, as you can imagine, his children were not super pleased about that. And so, to Christine's point, if you have no estate planning documents at all, stepchildren don't have a lot of legal rights. But the way that you protect not only your lineal blood children, your spouse, your stepchildren, and then prevent that, later term in life marriage from messing all that up is through talking to one of the attorneys here and having proper trust planning in place, I would say. Trust.
Let me just make one other point. We all know families where there are children, but the children are detached from the parents. The children, for whatever reason, aren't active in the lives of the parents. But the niece is. Okay, but if you don't do any estate planning, the law says, oh, this person passed away, they have these children, that they are lineal descendants, and so the stuff is going to go to these children. Well, that's not necessarily what the decedent would have wanted, because it's the niece who's always taken an active interest in their life and supported them and on and on and on. That's why it's important for people to, no kidding, think through, what do you want to have happen with your stuff? And your plan should reflect what you want. It shouldn't reflect necessarily what somebody else wants. So when I talk to clients and prospective clients, I joke about it, but I'm serious. It's interesting what your children want, but it's not their stuff. It's your life, and it's your stuff. And so you have to think about that, and I'm certainly encouraging folks to have that conversation as a family, but ultimately you have to decide. Then the professionals can help you get all the right documents and paperwork done so that what you wanted actually happens. Because if you don't do it, over and over and over and over, we see cases of things that get drug out and litigated, and all of that could have been avoided if somebody just had a good plan in place for themselves.
Definitely.
So,
And then I'm not trying to talk more. I'm going to kick this to Christine. For those of you watching online, thank you. You can chat in questions anytime. Thank you for doing that. Miss Elizabeth Coatsworth has a question, Christine. Which protects one the most, a power of attorney, a will, or a trust?
Thank you for the question, Elizabeth.
Yes.
Okay, thank you for the question, Elizabeth. I guess just at a basic level, a power of attorney is a document which plans for incapacity. So this document is going to say, or unavailability. Say you get stuck in Europe due to COVID, then the person that you've designated as your power of attorney is the person who is able to take care of your finances, your assets, take care of your property, pay your bills, and that would be in the event of your incapacity, unavailability. At the moment of your death, that power of attorney no longer has any effect. So then your estate is governed by the terms in your will or your trust. In terms of the will or trust, which provides the most protection, they're just completely different documents. If your plan is to avoid probate, or if you want to spell out the way that your assets are going to be distributed to certain people, some things will be held for longer. You have a trustee that you want to make sure that somebody who is having trouble managing their finances doesn't get assets, then you're absolutely going to need to have a trust to spell out all those wishes. Your will is a simpler document, but it is by no means unimportant. Your will, you name who you want to have to get the assets of your estate, but it's generally more of a short term. I passed away. I have 2 children that are 50. They're responsible adults, no problem. I want my estate distributed 50-50 to these 2 kids, and then that's the end of the will. The trust is generally for more long-term planning and can help avoid probate, but a will and a trust are both very important documents, and both provide a lot of protection.
Definitely. Thank you. And that's all the questions we have from the chat.
Great. Yes. Thank you, guys. All right. To piggyback on what Hugh was talking about last, something that my late mentor used to always say to the clients is that inheritance is not a right, it's a privilege. And so think about that when you're putting your estate plan in place. So, all right, we saved the most exciting topic for last, will and trust disputes. On our panel, we have Mr. James Wright, CPA with Carr, Riggs & Ingram. Ms. Stephanie Duffield, financial advisor with Edward Jones. And Attorney Jim Green with Clark Partington.
All right, well, good morning, everybody. Thank you so much for sticking around for the last session. We promise it will be well worth your time. So we wanted this to be a conversation between you and us, so feel free if you have questions along the way to raise your hands and ask the questions, and then we'll also have a second question and answer session at the very end. But this particular presentation is called Will and Trust Disputes, and we all know what that is just by the terminology. And as a financial advisor, I always say we want to have these conversations now while we're happy and healthy, because if something happens to someone, to your parent, and you haven't had these conversations about mom and dad, what's going to happen at, when they pass, or yourself, if you get a terminal illness, we've all been through these experiences, and rushing through these conversations when you have an end date in sight and when things are very emotional when someone's sick just becomes very cumbersome and a big burden to really that person and the entire family. So today we wanted to have conversations, and we're going to start with some simple case studies about things that have gone wrong in our individual practices. And so we wanted to make this very personal, just to highlight some things that could have been done a lot better or a lot more efficiently, which would have ended in a much better result. So the goal really is if you take one little nugget away from this panel, and even if you've done your estate plan or your trust plan and you realize, you know what, I better think through that piece of the puzzle, and you make that change now, we will feel like we have had a meaningful impact today. So this is James Wright from Car Rigs. He's from our Blue Water Bay, or his Blue Water Bay office. And this is James Green. He's an attorney with Clark Partington in Pensacola, and I'm with Edward Jones Investments in Destin, Florida. All right. So I think the last panel did a good job. I'm glad they ended it talking about the difference between a will and trust. So we're going to just start with, again, a case study, and I'm going to talk about a real-life experience that ended up being an absolute disaster and actually happened in this last year of my practice. So I've titled it The Life Insurance Beneficiary Disaster, and I was working with this particular doctor for several years, a very high-income earner, made over $800,000 a year. He moved to this area from Tennessee, had a really big, their dream home in Tennessee, lost his job. He was a 1099 contractor. So he came into my office and we put some really thoughtful, meaningful planning in place with a big defined benefit plan, which allowed him to put, you know, a couple $100,000 away a year, tax deferred, and some 401k buckets. So that's really how I met him. At that time, his wife was a teacher living in Destin, and he ended up having a third residence in Pensacola because that's where he ended up working. So very convoluted, very expensive situation for the first few years. The market wasn't really moving in real estate, and so they were kind of floating 3 mortgages, or 2 mortgages and rent, I should say. This got very expensive, and he fell ill with cancer and ended up having a very long battle with cancer. So I know on my end as a financial advisor, I have to be very thoughtful and go over each and every asset. And we did that within my book of business, and we did that outside of what they had done prior to what we did together as well. And, you know, we did things at that stage like add the wife to the defined benefit plan so that she, when he got sick, could call in and give me instruction on the accounts to liquidate the assets. We're so glad we did that because we did liquidate those assets over the course of a couple years down to just a very small bucket that when he passed he left behind. And also it gave us the ability after he passed to just move through closing out those accounts. They're a little bit more cumbersome, they're complex in nature, so we were able to close out those accounts very efficiently. But there was one piece of the puzzle that offered a lot of solace to his wife, and it was this life insurance piece that he had been sold years before, and we were so glad he had it because obviously he was very quickly after I knew him uninsurable. And we'd always talked about it, I'd seen the policy, and we always just knew that was what was going to take care of his wife after he passed. Well, lo and behold, he passed away. And very, very unfortunately, the beneficiary was a trust that was never finished being created and never funded. So the wife thought she would receive this very large tax-free inheritance, which is now still going through probate. So it's been a very painful situation, very emotional, and could have very easily been dealt with if he would have allowed me a little bit more transparency. But at that stage of the game, he was very sick. And remember when I said at the very beginning you want to have these conversations with when you're happy and healthy? Sometimes things like that become very emotional towards the end. Second disaster was a real estate crisis. So lovely client, was widowed for several years, had a beautiful house on the water. Her largest asset was this house on the water, had 4 children, and had memories for decades in this house on the water of her kids and grandkids, and her wish was really to leave it to her kids. So she got her wish. She passed away. The house went to her children. There were 4 children. One of them was a very high income earner. Another one, upon her passing, had lost their job, wanted to move into the home, and the other 2 were happily married, house spouses, and, you know, just the day-to-day with their kids and whatnot. So not thinking through what that would look like, things became very contestable after she passed. The one child moved into the house. They couldn't support all the bills equitably, and the other 3 were not so happy to pay for the one, you know, sister to live in the house. So essentially what happened was it ended up in a lawsuit. They ended up selling the house, and I really think with this particular client, if she would have known how things would have ended up, things could have been done differently. So, you know, I always
say with clients, I'm not allowed to give I can give financial advice, I'm not allowed to give legal advice or tax advice, but I just walk through these cases with clients because, you know, if you have a situation like that in your family, it just ends up being very emotional and not really meaningful. I think she would just be devastated that her kids don't really talk now. So that's my 2 cases.
All right, as everyone's already said, my name's Jim Green. I'm an attorney, and part of my practice involves estate and trust litigation. And one of the things I get asked to do by clients frequently is to help them evaluate whether or not a will or a trust is itself a valid instrument. Because under certain circumstances, you can have one of those set aside. For example, what if you had gone to meet with a financial planner and you've met with a lawyer and you've got a will and you've got a trust and maybe you amend it 2 or 3 times as your circumstances change and you're hoping to take care of your children, and then you fall ill at the end of your life, you have an in-home caretaker who the children have no reason not to trust, but when you die, they find out that there's a will that undoes all the planning you had done with your planner and your attorney and gives everything to your end-of-life caretaker who you really didn't even know. Sometimes there will be one sibling who thinks they deserve it all and will isolate the parent from the other siblings and manipulate them into believing nobody cares for them except for that one child, and therefore you should leave it all to that child. That's something else that could potentially be set aside. I'm glad they talked about the blended family earlier, because the example I've got up on the slide I've called the stepchild dilemma. But this is a situation where 2 people had children from prior marriages, and they owned real property individually prior to their marriage. They get married, stay married for 40 years, they get close to their stepchildren, they create these mirror image wills that say, my individually owned property goes to my biological child, everything else goes to my spouse, and if they predecease me, then everything's split between all the kids. In this particular instance, the mother had a daughter who lived out of town, and the father's children were in town and helped take care of her when she got cancer, took her to all her appointments. The dad dies in October. The daughter comes in town, takes the mom away, starts taking care of her, won't let anybody else see her, ends up getting a will from her mom that leaves her everything, ends up getting deeds to her from the jointly owned property that was supposed to be divided among all the kids. And then the mom dies 2 months after the dad, and the children of the father are thinking, what happened? We were supposed to split it between everybody, and now she gets everything. So there are different mechanisms under the law that allow you to challenge a will or a trust, or even a life insurance beneficiary designation, even a joint account ownership designation. And after we finish the case studies, I'll speak a few minutes more about what to look for to see whether or not, under your circumstance, one of those documents can be challenged.
Good afternoon again, and thanks for hanging with us here in person and watching online. So a lot of times when the accountants are brought in, it is definitely for us to crunch the numbers. And so this was kind of one of our situations, which I call sisters versus brothers. Dad had already passed away. Mom dies. There's 4 siblings. And we've got plenty of estate documents. All that stuff's pretty and nice. It leaves everything equally among all siblings. But unfortunately, one of the siblings did not believe that the accounting had been done properly, the assets had been valued properly, and thought they were entitled to a larger share than what was being proposed. So we had to come in, and the eldest son, which typically happens, the oldest sometimes is left as the executor. And I will make this comment. That is kind of a common theme that you see, that the oldest should be the one who's left in charge, but it may not need to be the oldest. Maybe it is the middle child or the youngest child that has a better acronym for that. I'll take my family example. My grandmother recently passed away, and my mother is the oldest, but she is, bless her heart, she's wonderful, but she is not a business person. My uncle, who is the youngest, there were just two siblings, is the business person. So he was rightfully named the executor, because even though maybe, and my grandmother actually asked my mother before she did it, because of that old thought process that it needs to be the oldest. Do you mind? And of course she immediately said, please do. I have no problem with it whatsoever. So in this case, it was the eldest son who was perfectly capable of being the executor of the estate, but because they were responsible for doing the accounting, and I will recommend, depending on the size of the estate, it may not always matter, but sometimes it is better to get a CPA in on the front end to do the estate accounting, so that if there's any issues, the executor can at least come back and blame the accountants versus blaming the executor who's trying their best but maybe has not had to deal with this before. So we had to come in, we had to do a whole new estate accounting. There was some multiple properties and stuff, so we had to get some assets valued. And the sad part about it is, we were representing the estate, so we were the CPAs hired by the estate. The sibling that was challenging everything had hired her own experts. You had to have a lawyer for the estate. You had each beneficiary had to have a lawyer, even the children that were on the side of the estate. And unfortunately, accountants and lawyers, we sell our time. And that's how we make our living. So we had to get paid for our time. And Mom passed away in 2011. This finally was settled at trial last year. So you've had that long a time of this going back and forth. Unfortunately, I fear the relationship among the siblings is irreparably harmed. The one sibling that is challenged has been outcasted by the three others. And in the end, they would have all gotten more money in the shares if they could have had to come to an agreement before they got all the lawyers and accountants involved. Not to mention all just the emotional tear that this took on everybody, especially it getting stretched out so long. So sometimes you can have the documents, they can be beautiful, they can be doing exactly what Mom intended, but there's no way, kind of like to Stephanie's point in her example, that Mom would have wanted her children fighting like this. So that is kind of some of the sad things that can happen from time to time. So now we're going to go back to Stephanie talking about a few of the things that are involved with wills and trusts.
Okay, so also you want to be really thoughtful about who you choose as either a trustee or an executor. So we just went through in that last panel. They did a good job illustrating the difference between a trust and a will. And an executor is the person who's in charge after someone passes when there's a will. And the trustee or co-trustees is the person or people who are in charge after one's passing when there's a trust that's put in place. So I just want to point out very thoughtfully that you really have to be thoughtful about your designation of if you have an institution or if you designate a person to accept that responsibility. Because sometimes people will say, I want this uncle. This uncle is wonderful in our family. My kids would absolutely respect his judgment. I want him to be the trustee. Sometimes the uncle agrees, but might regret it years later. So I just wanted to highlight a quick story. Again, happened within my book of business. I have a trustee who's been managing a trust I've been working with him 11 years, and the trust was ongoing prior to that. It's like the previous presenter mentioned, trust makes sense, especially when something goes on a long time. So this was a very large estate, and there are 2 adult children, and the way Mr. D, is what I'll call him, wanted things dispersed was so much every month, but then there's the ability for the trustee to make decisions along the way about whether or not Mr. D would want the trust assets dispersed for whatever instances come along in life, right? So this particular trust was a single trust created years ago. Client passed, his best friend, my client, is the trustee of the account. one of the beneficiaries got cancer, and so went to the trustee saying, hey, you know, I've got cancer. Can I have an allotment in addition to my monthly allotment from the trust? Can I take a disbursement for my cancer treatments? Well, he had to think through, what would Mr. D want? Well, yes, absolutely. The other one had some addiction issues. Well, would Mr. D want me to do that? Well, anyhow, the trust started being dispersed unequally, and it was very hard for him to keep track of, and he was so nervous about being sued. So he went before the courts and had the trust split into two. Well, a couple years later, the trust is now two trusts, and these two beneficiaries receive their monthly, allotment in their bank account from my branch. I'm managing the assets, and one of them, their cancer came back and they passed away. Well, the way the wording of the trust was worded was that that person's fair share would go to the other sibling, the sister. Well, he thought, I don't think this is what Mr. D would have wanted. This particular person has an only child, and I think Mr. D would have wanted her assets to continue on to her child. Well, guess what? He had to go back before the courts and argue that his friend, Mr. D, would have wanted this to happen. So I just share that story because I can't tell you how many times he said, I wish I would have never agreed to be the trustee for this account. He cannot wait until it runs out. And, unfortunately, there's other assets that will, come into play that will future fund the trust. I mean, this is going to be going on quite some time. So I just want to be thoughtful about that and share that with you because it's a very heavy burden, especially if it goes on years like that. And a lot of people think, well, it's a cheaper option. Institutions charge 1 or 1.5%. I don't want to do that. Well, usually these people end up, even if it's not written in your trust, my client takes a payment. I mean, it's a lot of work, right? And he charges less than the bank because morally he feels that's, the right thing to do. But I just want to mention it's a burden. And then, titling the assets appropriately. If and when you do these things, I've met people when they come into my office and I'm like, well, great, let's talk a little bit about estate planning. Tell me about what you've done. Oh, we have a trust. And I look at their Wells Fargo statement or whatever it is before they transfer it to Edward Jones, and I'm saying, well, why aren't your assets, why isn't your $800,000 account in your trust? Oh, well, I don't know, and really, you have to think about it. These trusts are just a piece of paper until your assets are titled. So, when you have a trust, please make sure that you provide the trust information to the financial advisor, and we're able to title your assets appropriately. And if you choose not to create a trust, please make sure you also have that conversation with us, and a good financial advisor will proactively have this conversation with you, but we'll put something called a transfer and death on the account. And I always encourage clients as well, do this at the bank too. So when you go to the banker is most likely not going to say, put this payable on death on your $10,000 account. Well, I've seen from experience it actually happened to my mother before I was a financial advisor. She had an account, we met with attorneys, and the attorney said, all of that's going to get eaten up with fees, so you might as well just leave the asset and come back years later and try to, if there's some left, you can come after the asset, essentially. So really, really difficult things, but again, make sure things are titled appropriately. Next slide, please. Oh, perfect. That one. Then you also want to just make sure that you update things. Life changes, and one of the great things about, say, if you create a trust is that they're amendable, right? We've heard that several times this morning. So just because, I always tell clients, it's always the right time to do the right thing, even if your mind might change. And it's often the case where we'll have a new grandchild be born, or there's a divorce in the family and that type of thing. So you'll want to make sure every couple years, and sometimes attorneys are really good about this, they'll send a letter out to clients if they've created a trust and just remind clients to look at their trust documents every 2 to 3 years. And really that is something also that I'm really passionate about doing in my practice is, hey, have there been any updates since you created this trust 10 years ago? Okay, let's think through those. Does it make sense to have an amendment? Okay, let's put you in touch with an attorney who can create that for you. And then lastly, I just want to talk about the importance of transparency. All of these documents, as I mentioned, are just documents unless someone knows where they are at execution time. So we heard the phrase living will, health care directive, power of attorney. It is horrible when the financial advisor doesn't have a power of attorney on the account and someone is sick, and all of a sudden, you're having to rush things and get the power of attorney and have your legal department review it. It's just a mess. So again, please, if you have the documents, share them with us. And also on the flip side of things, it might make sense for you to download an app. I know everyone's kind of moved to having things on their cell phones these days, but think about getting that call from, your son in Montana or whatever, or, your son in Montana gets the call that you're in a coma, and he flies out here, and he knows he's the decision maker, but he has no idea where the documents are. Well, there's some great apps. There's one called Evernote where you can actually download those documents on your phone, and so you can show up at the hospital and show them, here's the living will, here's the healthcare director, I'm the person who's in charge of making these decisions for my mother. So you just want to be thoughtful about that. If you don't want your beneficiaries to know how much they're going to inherit, that's okay. Just let them know where to find the documents, safety deposit box, in the library, third shelf, whatever. Please let them know where those documents are, and if you're comfortable enough, giving them a copy is also really, really meaningful.
All right, well, there are 3 ways you can challenge a will or a trust. And the first way is if they're not properly executed. One thing that's important to realize is under Florida law and under most states' law, there's a presumption in favor of the validity of these documents, because the only person who really knows whether it contains their true intent is dead by the time you're challenging it. So one way they help ensure that the documents contain the true intent is require that they be witnessed by 2 witnesses. And there are certain rules about how it has to be signed in Florida. People can do it on their own, but if you want to make sure it's properly executed, I think it's worth hiring an attorney to supervise the execution and to draft the documents to make sure everything works the way you want it to. But if it's not properly executed, it can be set aside for improper execution. The second way you can set aside one of these documents is if the person lacked the mental capacity to execute the document at the time it was executed. Because of the presumption of the validity of these documents, the testamentary capacity test is the lowest test under the law for mental capacity. All you have to know is who the objects of your bounty are, and that means the people who have a claim to your estate after you die. So if you know about who you're married to, if you know who your kids are, if you don't have kids, who your brothers or nieces and nephews, if you can keep those people in your mind, while at the same time understanding in a general sense what your assets are. You don't have to know how much money is in your accounts, but you have to know you have accounts. You may not have to know every single piece of property you own, but you have to generally know you own property. And so you have to be able to keep in your mind who the objects of your bounty are, what you own, and then understand in your mind the consequences of leaving it to one person, but that means it's excluding these other people who have a claim. If you can do all that at once, you have testamentary capacity and the will would be valid. Another important thing is people in their old age, they fluctuate. They have good days and bad days. And under Florida law, you can have a lucid interval, which means for that day, you were good enough to execute it, even though generally you may not have been. And then the last way you can set aside one of these documents, which is where most of the time it falls under this category, is called undue influence. Sometimes they say coercion, duress. But basically it's where one person basically overpowers the free will of the decedent and gets them to do something that they didn't really want to do, but it's what the person benefiting wanted to do it. And it's usually done in secret, behind closed doors, so nobody knows it happened, like in the example of the caretaker who just shows up with a will. Or it can be a sibling who just shows up with a will. I've actually had cases where it's parents against the surviving spouse's widow or former husband. But because it's done in secret, under Florida law, they've created this presumption of undue influence where you can prove certain circumstances. And the circumstances are there was a confidential relationship between the decedent and the person who's benefiting from the will. That's almost always true. A caretaker gains your confidence. They rely on you. They trust you. Caretaker can tell them things like, I'm the one that's helping you. Your kids aren't around. Those kinds of things. The second factor is the substantial beneficiary, which is basically always the case, because if they're not changing it to the detriment of others and the benefit to themselves, you wouldn't be challenging it. And then the third part is called active procurement. And that just means the person benefiting was involved in obtaining the will. There's several factors they consider this, if the person who's benefiting is present when they sign the will. if the person who's benefiting is present when the testator expresses a desire to make a will. If every time they said they want to give it to me, I'm sitting there right next to them, well, maybe that's because I've coerced them into believing I'm the one that's there for them and nobody else is. If they get the attorney, in the example I mentioned earlier, the surviving spouse, the mom, had an attorney who had done the prior estate planning and who was helping her probate her deceased husband's estate. Well, the daughter takes her to a totally new attorney she had never met before and gets her to do a new will and doesn't even tell that attorney that she has stepchildren. Knowledge of the contents of the will prior to its execution, keeping it safe after the will is executed, getting your friends to execute the will. These are all things that are included in the law because they're things that happen all the time. Where earlier people were talking about maybe you have one kid who you don't think can handle having all the money. Well, sometimes there's one kid who thinks I'm entitled to all the money, and they're very, I have clients who describe these kind of circumstances, and then I can tell them all about their sibling who took everything because they have so many similar characteristics. They usually think they're the smartest person. They think they're the most entitled. Sometimes you could call them a narcissistic type of person. And when I start describing it, they're like, that's exactly right. That's my brother. I can't believe you know all this. Well, I'm like, that's because I've done this 100 times, and it's just a repeating circumstance. So, I guess the point of this is when you're in a family situation and you think your parents have done all the planning necessary and you've got all this history of wanting it to be done equally, and then at the end of the day it ends up all going to one person, there might be something they can do about it, and it's definitely worth calling someone like me or another estate litigation attorney to at least find out whether or not those documents are subject to challenge or valid. And as I said earlier, you can challenge all kinds of instruments controlling what happens after you die.
Okay, so kind of what I was talking about earlier, like from our perspective, when do the accountants come in? And like I said, it's typically we're hired by it could be the personal representative or the executor of the estate, the beneficiaries, or both. Normally by the time we come in this case, it's already gone to the point where there's going to be at least the beginnings of litigation. Everybody hopes that you can settle and those types of things, but there is some kind of litigation track started. Obviously, since it's litigation, the attorneys take the lead. So we work with the attorneys based on what they need us to do, what the issues are. Is it challenging the actual accounting of the bank account? Or it may be that part of the assets is a family-owned business. So do we need to come in and value the business? Maybe there's a dispute on the value of the business. And so our role basically really depends on the situations involved as well as what the attorneys need. And then a final thing to kind of keep track of, and Luke talked about this a little bit earlier, but are the estate tax issues. As we discussed earlier, the estate tax exemption is at 11.2 adjusted for inflation, so it's actually 11.58 for 2020. So a lot of people think, well, I don't have that much assets, so I don't have an estate tax. Well, with estates, there are two taxes. There is the estate tax, but there's also the income that is generated off the estate assets. And if you have gross income in an estate of more than $600, the IRS says you must file an income tax return for the estate. So the income from estate assets can be taxed at two different levels. They can either be taxed in the estate if distributions have not been made to beneficiaries, or if the assets are distributed to the beneficiaries, then the beneficiaries on their personal income taxes would pay the associated taxes based on their personal income rates, taking into account anything else they might currently have. From a tax savings standpoint, You know, as Luke mentioned earlier, the tax rates on estates and trusts are very condensed. For 2020, if you have income over $12,950, you're taxed at the top rate of 37%. That also means that if you have capital assets, you're already at the top rate of 20 or 23.8% on capital gains. Whereas to get to the 37% on an individual's basis for married filing jointly, you'd have to have $622,000 of income before you got there. So from a tax perspective, if distributions can be made and there's no issues, we encourage that because it does save money in the family pot, because not as much of it is going to Uncle Sam. But in order to do that, the cash or the assets actually have to be given to that person who is going to be expected to pay the taxes. So they need the rights to that income. So that's something that some people I talk to all the time, they think, well, I don't have a estate tax problem because I don't have $11 million. But is it a brokerage account with Stephanie that's still throwing off capital gains and interest and dividends, or at a CD or a money market account at the bank that's still throwing off interest and dividends? Like I said, there may be some other expenses you can take, so you may not have taxes due, but if it generates over $600, the IRS says we want to see a tax return. So those are a couple of things to keep in mind. And so that kind of brings us to the end of our piece of this. We would definitely love to take any questions if anybody has any. We certainly appreciate everyone's time and being with us here today in person or watching online. And I think, Amy, we need to do a giveaway. Okay.
So, what is, I know it's going to be a really hard question, but what's kind of an average cost of a will or trust deed?
Can you repeat that question?
Sure. The question was, what is the average cost of a will or trust dispute?
I know it's a really hard question.
So that's a wide range. Okay. The low end is going to be $50,000 to $75,000, and the most I've been involved in is several $100,000. So it's very, very expensive. And what James mentioned earlier is sometimes all of the estate ends up in the hands of the attorneys and the accountants, and the courts don't like that. But sometimes people are just unable to get along. I'll tell you a real quick joke. My dad used to do estate litigation too, and he said that the difference between a divorce and a will contest among siblings is that instead of having half your life to learn to hate the other person, you've had your whole life to learn to hate the other person, which is a sad but sometimes true statement.
All right, so I do have a door prize. Yes, sir? Oh, sure.
So, we're here about estate planning. On average, to go to one of the fine folks who have been talking to us today, what could one expect to pay to do the full package of the will, the living will, the estate, on average? And I realize it depends on how big that is. A ballpark figure would be nice.
I would say somewhere between, if you're on the very simple end, $1,500 to up to $5,000. And then if you've got a significant net worth, then it could be over $5,000 for those individuals that have a taxable estate. But if you pay an attorney, even if you paid an attorney $30,000 to put a whole plan in place and do some complex planning, for that type of planning, you'll be saving hundreds of thousands of dollars in estate taxes. But most people don't need that type of planning. So you're probably looking at $1,500 to $5,000. Well, our sponsor has provided a door prize. I had put a sticky under a chair, but since we don't have that many live participants, I have written a number on a piece of paper. So everybody, all of our participants that are here, if you'll just throw out a number between 1 and 100. Okay. Okay. 13? My number was 12. Very good. Oh. Oh, I have to do it over again?
Yeah, we can do it again.
Okay, I'm going to do it again. But now y'all know where I was thinking. Okay. All right, so y'all give me your number. She's writing down her number.
64.
27. Debbie.
72.
22.
She got it again.
The 30,
27 is closest, right? No, 33. Yeah, 27. You win it, you still win. It's meant to be. Meant to be.
So I guess we're good, huh?
Yes.
Good job, bud.
good job, thank you.
That's really good. Good job.
Hey, just wanted to thank everybody again for coming. Thank you to our online participants, and hopefully we will see you again next year. And we do want to remind everybody that we have some of the supplements available for the people in the room, and we will have a link to the supplement posted on our website and our Facebook page. So thank y'all again.
Hancock Bank and Whitney Bank first worked together in 1918. In 2011, the two banks merged to become one company, built on 5 timeless values: strength and stability, honor and integrity, commitment to service, teamwork, and personal responsibility. With this foundation, our mission is to help you reach your dream. One bank, one mission, 100 years in the making. Hancock Whitney. Your dream, our mission.